Good morning, everybody. It's Friday. Welcome to the Courtroom Files Live, and we have a treat this morning. Judge Glazer's back. Yes, the return of Judge Grumpy Pants. Let's see if she's in a better mood after her sabbatical.
He admitted sending a letter to the FBI in Miami in January 2025, and he used somebody else's inmate number to conceal his identity. He sent a fourth letter in February.
Corrections, does he have a bond on any of the open cases?
There's a 10th letter, May 5th.
I'm looking, it's a lot of
Is there anything
different,
no bond?
let's see, one case that's 75 plus house arrest.
What do you want in this case, Dave?
I mean, if he's already being held no bond on something else, then maybe.
I don't see no bond, I just see a bunch of cases and
The F-24 case is probably no bond, no?
F-24.
4643.
1643.
Oh, he's on probation, no bond, Judge.
All right. 1 second. Give me 1 second. So I'll set the bonds as follows. Just making a finding of probable cause. Count one will be $10,000.
5,000 for count one?
No, I said 10,000 for count one. Count two is also going to be $10,000. I'm increasing the bonds based on what's contained in this arrest affidavit. Count three, 4, 5, 6. It's not a conspiracy. 3 through 6 will be 2,500 each count. Wait a minute. 7, $10,000, and 8, $10,000. All right. Have a nice day. You'll see a judge in 21 days for the arraignment, probably. Next case.
I see the guy from Ward D as well, once we finish the out of turns.
You have Ward D?
I see them on the Zoom.
Okay, thank you. Michael Whitfield, page 19. Oh, hello. There's somebody on Zoom. Is Mr. Whitfield here? Is he refusing?
Yes.
Battery by a detainee?
He's present.
Okay. Hi, Mr. Whitfield. Good morning, sir. You were arrested for battery by a detainee on another detainee. I will appoint the public defender's office for you. There's probable cause for the charge. I'm setting your bond at $2,500. All right. Have a good day, sir.
Eric, the clerk, can you call corrections, please?
All right. Who's on Zoom? The hospital case? Is this Mr. Ruiz?
Yes, ma'am.
Good morning, Mr. Ruiz.
Good morning.
Sir, you were arrested for a case from July 7th. The charge is possession of a controlled substance, criminal mischief over $1,000, and possession of drug paraphernalia. I will appoint the public defender's office for you. Let me review.
You guys called somebody.
There was only a crack pipe.
Mr. Ruiz, please do not make any statements or comments about what happened while we're in court, okay?
Okay.
So there's no value I see for the damages, right?
Correct.
That's
Correct.
correct.
All right, what do you want?
Pat, please.
Any objection, state? I'm okay with TAP.
Okay.
TAP alternate bond. Count one, possession of a controlled substance. It's
What would you consider
$1,000.
ROR?
Actually, it says 1 gram of cocaine residue. It's fine. $1,000, count one. Count two, criminal mischief is $150. Count three, possession of drug paraphernalia, $150. I'll make it 500 for count three. So we need a date to come back to court in 30 days.
There may already be.
Or maybe an arraignment date.
I don't know.
They
Alright.
gave me pre-trial release.
It should be at August 11th would be the arraignment date, but let me see and see just.
Let's see if there's a date. Thank you.
$728.
You have to come to court for your arraignment on July 28th at 9 a.m. Courtroom,
August 28th or it's already July 28th?
August, no,
Oh,
August,
it's
July 28th.
July 28th already, okay.
I'm at a station with a pre-trial release, right?
How was it July 28th if he was arrested?
It's in judge, it's here, CJS.
Let me.
It says arraignment date,
Oh, it'll be
July
21
28th.
days from the time that he was
28.
arrested. They would
Yeah,
already. court
that's
date was
7/7.
July 28th. July 28th at 9 a.m. Courtroom 27, Judge Rodriguez.
Mr. Ruiz, do you have an address?
Would it be pre-trial release like they told me?
Do you have a place that you live at? That you
It can be verified.
pretrial services? Because I think pretrial might have already interviewed him maybe when he first came into jail and then he was transferred to the hospital.
No, never got interviewed.
No? Okay.
Is Tap here? Oh, hello, Tap. Hi. Thank you. Okay, so we have, we'll give you the paperwork in a second. Thank you.
Mr. Ruiz, please contact the public defender's office as soon as you are discharged. Do you know when you might be discharged from the hospital?
No, I don't, man.
Not yet? Okay.
All right. Have a nice day, sir.
Thank you, sir.
Oh, and my things from the hotel.
Just, I don't,
Could you give Mr. Ruiz the public defender's office phone number, please?
I will.
Thank you so
Thank
much.
you. Thank you.
do you have Sandy Ventura or you want me to go start the regular calendar?
They took him back to jail arraignment. We can pass.
Okay. Is there a private lawyer here or no?
Elaine Gonzalez.
It's a mother. Huh? It's somebody's mother, it's not an attorney. I'm doing my females, then I can start calling out attorney. All right, next is Abigail or Aranga. Page
I thought you
one,
wanted to do Elaine Gonzalez,
huh?
the private attorney case. I thought you wanted to do the private attorney
Is
case.
she a private attorney or is that somebody's
Ms.
mother?
Casa Pajaha is here.
Elaine Gonzalez has a private attorney.
Oh, Alan Gonzalez. Yeah, he's a private lawyer. Jessica Casa is a lawyer.
Hence,
Okay, thank you.
that's number 32 on page 10.
Thank you. All right, good morning. Page 10.
Elaine is present. You speak English or Spanish? English.
I'm sorry.
Good morning,
hold
sir.
on.
This is number 32, Elaine Gonzalez.
Alan. Anyway,
Alan.
good morning, sir. Do you speak English?
Yes, good morning.
All right, sir, you were arrested for a case from August 5th of 2024. The charge says attempted fleeing and eluding a police officer at high speed. I believe it's just the one count, right?
That's the only count before the court.
So your attorney is present. Good morning. Can you please announce counsel?
Yes, good morning, Your Honor. Jessica Caso Pedraja.
So
Good
Judge,
morning.
if you look,
Judge,
this
I
dates
was-
back to August of 24. So there is no hold. It's not an attempt. You actually got away from the officers. My concern though, Judge, is that the defendants got prior convictions for fleeing and eluding in 2018. He's also out on bonds for, it looks like cases including fleeing and eluding. Correction, do you know what his bond is on those open cases?
He paid a partial bond. He went to house arrest. Count 1 was 75, count 2 was 7,500.
Was it, do you know what level of house arrest or no?
I believe he's level 1,
No, I
Miss,
don't think, they don't have it on the jail card.
Date, I believe he's level 1. I could look it up really quick. He picked up this new case while he was out. They had some other A forms. He was arrested. While he was arrested and he was in custody, they dropped an A form, judge, and then he got bonded out because that A form predated the original arrest. And then while he's out, house arrest called him and asked him to meet him at the police station, and they just dropped another A form that predates everything as well.
All right, so it sounds like there should be no hold. Is that correct, State?
Yes.
All right, no
Judge,
hold.
I would ask for the standard bond if that's possible.
All right, no hold on F-25 13806 and F-25 1388955. So there's probable cause for fleeing and eluding a police officer. The bond is $7,500. Good day, sir.
Thank you, Your Honor. Thank you,
Thank you.
State.
Miss. You have a good attorney. Listen to what she tells you. Right now, calling up Abigail Aranga on page 1. I don't know, somebody's raising their hand, but it's not the victim, so I don't know why I need to promote anybody.
Same last name.
Uh-huh, and I gotta hear about it. I don't need, ma'am, I don't know what you have to say, but if you're not the victim, I don't need to hear from you. Good morning, this is Miss Aranga. Do you speak English, ma'am?
Yes, ma'am, I do. I'm in the
All right.
wrong court. I didn't know it's in downtown now, so I'm on the
Are you,
14th.
ma'am, Miss Maria Aranga, am I speaking to you? Do you think I'm speaking to you or your daughter?
I'm sorry, I thought you were talking to me, Your Honor.
No, I don't know. I promoted you just to be nice, but if you're gonna
Thank you.
interrupt, I'm gonna put you back as an attendee. I'm not speaking to you, ma'am. So I take it, Miss Abigail Aranga, you speak English, ma'am?
Yes, I do.
All right, you got arrested for a case from April 15th. It's false imprisonment with a deadly weapon, child abuse, 2 counts of aggravated assault with a deadly weapon, 2 counts of battery. And I will appoint the public defender's office for you. I need a moment to review the arrest affidavit for probable cause. So one moment, please.
Okay, well, she's taking her dear sweet time. Good morning once again, everybody. Happy Friday. Welcome to the Courtroom Files Live. I think she just recharged her hateful batteries. Let the hate flow through you. That seems to be the default Judge Glazer setting. But that's what makes it fun. Let's go back to her for just a couple minutes.
Mr. Ranga denies the allegations. This is a delayed arrest. This incident is alleged to have occurred April the 15th. Mr. Ranga has since moved. She attends college. She is working. She's attending college at Miami-Dade Community College, studying crime scene investigation.
Okay. So ma'am, yeah.
I would ask if you would consider house arrest, Judge, for this. She's already away from that location.
State you have an objection to house
I
arrest?
mean, she grabbed somebody's 4-year-old child and said she would stab him.
She,
I believe the
she
time she was
denies those
armed with a
allegations,
knife.
Judge.
Pardon me?
She denies those allegations, Judge.
I'm finding probable cause for the charges, although the child abuse and battery are the same element. I don't know if a 4-year-old understood her
I think
holding
the
a knife.
4-year-old would understood him being grabbed and threatened with a knife.
Ma'am, you are ordered to stay away from the alleged victim, Yara's Lady Herrera, and her child, the 4-year-old child whose initials are EH. No contact with those alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victims, their home and school, and place of employment at all times. Do you understand the stay away order, ma'am?
Yes, ma'am.
Thank you. So, I don't see any priors. I understand
She's got
not
serious
guilty.
prior arrests that did not result in conviction.
Right, I understand. All right, I'll do house arrest with a GPS monitor. Level 3 house arrest with a, I guess, no curfew, but house arrest, level 3, alternate bond. Count 1, the false imprisonment will be $5,000. Count 2, child abuse. It's all like necessary. This, child abuse would be, I guess, $2,500. Count 3, aggravated assault with a deadly weapon will be $4,000. Count 4, aggravated assault with a deadly weapon is $5,000. Count 5, battery is $1,000. And count 6, battery is $1,000 with a stay away order from the victims. All right,
Sorry, what was count 6?
$1,000, so it's, let's see. It's 5,000, it's house arrest level 3, alternate bond, 5,000 count 1, 2,500 count 2, 4,000 count 3, 5,000 count 4, 1,000 count 5, 1,000 count 6. All right. Thank you for coming in. Make sure to keep all future court dates and stay away from the victims. Have a nice day. All right, next is the Veta Spicy, page 1. Did you say bond out?
Yes, spicy is a bond out.
Thank you. Zamara Hernandez Hung.
Spanish, please.
Yes.
Good morning, ma'am.
Buenos días, señora.
Ma'am, you were arrested for trafficking in amphetamine or crystal meth and possession of drug paraphernalia. I will appoint the
Sí.
public defender's office for you.
Señora, usted fue arrestada por traficar anfetamina o metanfetamina de cristal y posesión de artefactos para el consumo, parafernalía. Le voy a asignar la oficina al abogado de oficio.
You have her out on felony bond, F24 26219.
Hold for the division judge for that open case.
Aguante para el juez de la división en el caso de abierto delito mayor.
I'm
Mayor,
just reviewing for probable cause.
leyendo para ver si hay motivo fundado.
I don't see where it's trafficking. I apologize.
The judge, it was 16.2 grams. It's listed where it says note.
Bien, porque la juez decía
Oh,
que no
thank
veía
you.
tráfico, pero ya la fiscal aclaró que es 16.2
There's probable
gramos.
cause for trafficking in crystal meth. I'll set the bond on count 1 at $15,000 and count 2 possession of drug paraphernalia for $500. And you'll see your judge Monday. Have a nice day.
Cargo 1, 15,000 de fianza, cargo 2, $500 de fianza, va a ver el juez el lunes.
Next is Danielle Jones, page 2.
She's next door. Can we pass, please?
Yes, ma'am.
Okay, let's change things up a little bit. Let's go up to Michigan, Lenawee County, specifically Judge Anzalone. This was from a little earlier this morning. She had a sentencing hearing on an embezzlement situation. Let's check that out.
Is Eden Shikwana here?
Good morning, Judge.
There you are. All right. So, Mr. Falcone, have you received a copy of the pre-sentence report?
Yes, I did. Your
And you've had ample time to review that with your client?
Yes.
Okay. And you received it as well,
I
Ms.
have it, Your
Arnold?
Honor.
All right, so, Mr. King, have you had an opportunity to read and review the pre-sentence report? All right, so you're kind of soft-spoken, so if you two could stand in front of the podium by the microphone, and then Mr. King, I need you to speak loudly because we have to record this for appellate purposes, okay? So you've had an opportunity to read and review the pre-sentence report,
Yes, Your Honor.
and you've had an opportunity to discuss it with your attorneys.
Yes, Your Honor.
Are you satisfied with both of your attorneys and the advice that they've given you?
Yes, Your Honor.
Mr. Falcone, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor. I think there were 2 pre-sentence reports, and the last one we don't have.
Okay, all right. The one I have is signed by Mr. Moore for June 18 of 25 and sent to you on June 26. I only have one. Is that the updated one, Mr. Moore?
I'm assuming we sent out a corrected version, so I'm not sure on the date on that, but
Judge, that is the most recent, sorry.
Okay, thank you. All right, does the pre-sentence, well, I show he has no prior record, no misdemeanors, no felonies, and no misdemeanor juvenile offenses. The probation department has computed the minimum sentencing guidelines to be 12 to 20 months. Do you agree with that computation of guidelines, Ms. Arnold?
Your Honor.
And Mr. Falcone?
Yes, Your Honor.
Ms. Arnold, do we have anybody here who wishes to speak today?
We do, Gary King.
Okay, so I'll have you two have a seat again. And Mr. King. All right, and sir, I'm going to ask that you come up to that podium. And then I'm going to have you state your full name for the record, please.
Gary Dale King.
All right, and Mr. King, I know you're reading, but make sure when you look at anybody, it'll be me, okay?
Okay.
Okay, thank you. You may proceed.
No, I just want to go on record as stating that even though the court documents and everything show that everything took place from 2018 through 2023, we have documentation that states that it started years prior to that, to the tune of hundreds of thousands of dollars. So this was premeditated. It was obviously a retirement quick plan of some sort. So it was over a decade of weekly thefts. Now he's assumed the role of a poor, destroyed person, but yet he's still living an unhindered lifestyle. So in other words, there's money that still exists. This has got to be the worst white collar crime in the history of Lenawee County. I've looked a few things up, and the worst I could find is $400,000 embezzlement. And that person got 52 or 57 months in prison. To sum it up, he stole our retirement funds for his own personal wealth, put the family business in a financial crisis, and emotionally destroyed our father. He's openly admitted but guilty in court to stealing the money, So now I find it a slap in the face for him to be able to walk away in 6 short months while we have our dreams of a comfortable retirement taken away. He has ruined the family, destroyed the business, and taken away any financial support for future generations. I see the state guidelines state that for embezzlement over 100,000 could be a maximum of 20-year prison sentence. In this case, documented $1.7 million plus that he stole should somehow merit a means to reach a maximum penalty. My opinion is he should be imprisoned just as he has imprisoned us to keep working in our golden years. It will be improbable that we get our money back, but the longer prison term he gets, the less time he has to spend that money in front of us, rubbing it in our faces. Thank you, Your Honor.
Thank you, sir. Anyone else?
No, you're on.
Okay.
I did want to speak though.
Yep, I'm going to allow you to speak first.
Your Honor, what I wanted to say is, I just wanted to highlight and.
So can you stand at the podium?
Sure.
Just so it's picking up well.
Judge, I just wanted to highlight some of the stuff Mr. King said. One, the amount here is egregious. I'm sure it is the largest embezzlement in Lenawee County history. 2, the fact that it did happen over a number of years. And 3, that this caused heartbreak and really has impacted 3 generations of the King family in a profound way. And I could go into detail on that, but I know the court has the statements from David King, Gary King, and their daughters, Andrea Bash and Rebecca Keaton, which most eloquently express how this affected the family. And I hope Kevin King has read those statements and thought deeply about what's in those statements. My own experience in meeting with David King and Gary King, we met in my office and I thought, I know that gambling addiction can do serious things to people and they can commit crimes and do whatever they can to support their addiction. But, David and Gary King spoke with me and the 2 things that I took away is 1, they're not going to be able to retire anytime soon. And I know, Gary King just talked about that, but that's significant when they've lost years of their life when they would be able to relax, to enjoy children, grandchildren, pursuits, that sort of thing. They're not going to be able to do that now because Kevin King robbed them of that opportunity. And the second thing they told me when we met in our conference room was that Kevin King lived a completely lavish lifestyle. They talked about a super extravagant wedding for a daughter. They talked about many trips he took and how when he traveled, it was always flying first class, a limousine picked him up at the airport. They said he couldn't go get a drink without tipping $20. So I think this goes above and beyond a gambling addiction to support the kind of lifestyle that he wouldn't have otherwise been entitled to, and in the process robbing them of a comfortable retirement. So that's just what I wanted to highlight for the court.
Thank you. Mr. Falcone, is there anything you'd like, and you go stand with your attorney, please. Mr. Falcone, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. I know that today you're going to impose sentence, and one of the purposes of imposing this sentence is punishment. But I would like to remind the court that Mr. King did lose his marriage. He's been disinherited by his father, and his brothers will receive his share. He was working as a janitor. He'll never have a good job again, and we still are not done with the IRS. He'll owe taxes on all the money, and basically he'll be his life is ruined, and he will be impoverished for the rest of his life. So I would like you to take that into consideration.
Mr. King, is there anything you'd like to say on your own behalf?
Yes, Your Honor, I'm well aware of the emotional and financial damage I've done to my entire family. I'm not sure I'm going to carry this the rest of my life. I know I'll never be able to make it right with any of them. My hope is that maybe somehow I can make it better.
Was the 40,000 in restitution paid?
It was not, Your Honor.
Mr. King, let me go back here. Do you own a home?
I do not, Your Honor.
Okay, and you're divorced now?
Yes, Your Honor.
Was the home sold during the divorce?
It was not.
Okay, and your wife got the house?
Correct, Your Honor.
Did you get equity?
No, Your Honor.
All right, let's stay there. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It seems like the most egregious offenses that come before the court are perpetrated on people that trusted and loved them, whether it's murder, domestic violence, embezzlement. In this case, you know, it was a family company. They had immense trust in you, and you have devastated and changed all of their lives in so many ways. I don't know if it's the most money that's ever been stolen in Lenawee County, but you know, we had money stolen from band students who weren't able to go on band trips. We see this quite a bit because people trust people to be faithful and true to them. So there was an agreement at one point that if he paid 40,000, there would be a more minimal jail term, but he has not paid that.
Right, that was the topic.
Yeah, so there's a sentence of the court that you will serve 12 months in the Lenawee County Jail. You'll be placed on probation for a period of 3 years. You will have 1 day credit that you've already served. During the term of probation, you will obey and comply with all the articles of your probation. You will pay $750 in court costs, $130 crime victim rights fee, $68,000 in state costs, a $60 DNA fee. There's a $30 per month supervision fee, $60 if we have to put a tether on you. Restitution is set in the amount of $1,730,500.60. And when you get out, obviously you're gonna have to get more than one job and start paying on that. You're not to, Mr. Moore, is there an alcohol issue?
You know, I don't, not that I have, that I'm aware of, but I do know, you know, that he would drink, but you know, it's up to you, Your Honor.
Okay, so during a term of probation, you're not to violate any criminal laws. You can't leave the state of Michigan without consent of this court. You must report as required. Notify them of any change of address or employment status. You are not to participate in gambling or gaming activities or enter gambling or gaming establishments unless you first obtain written permission from the field agent. I can tell you I'll probably deny that if you ask. You must submit to search of your person and property, including but not limited to your vehicle, residence, computer, without need of warrant if the agent has reasonable cause to believe you have items which violate the conditions of your probation. You must maintain employment of up to at least 30 hours per week. Any tax refunds must be submitted to go towards the restitution and other fines and costs. Anything else, Mr. Moore?
It's off.
Yeah. Just say he needs to report to me following business day upon his release from jail.
So when you get released from jail, the first business day you need to report to Mr. Moore. We're open 8 to 4:30, Monday through Friday. So my bailiff's going to hand down to you your notice of right to appellate review. So we're going to have you initial and date 1 copy just for our records. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And then if Mr. Falcone and Ms. Earl could approach. Right. Make sure I did that right. Okay. Yeah, okay, thank you. Okay, me too.
Was there a second attorney?
Yeah.
I'll get the name, Judge. I'll get the name later. It's okay.
Joanne.
So yeah, I don't know what the right solution is for stuff like this. So I put up this this poll: if you ran the world, how much time would this guy get? And the majority of you said 10 to 20 years. And I think I have to agree from the standpoint of I don't know what you do in this situation other than punish somebody. In theory, the idea would be to get them in and out of jail quickly so they can start earning and start paying back. But one need only look at O.J. Simpson, for example, and the civil liability that he had, and the fact that that family never really saw a dime of that money to realize how hard it is to collect on any of that stuff. So I don't know. There's a victim that'll never get repaid, and the whole thing's just a mess. But I don't know. We have the best system on the planet, but there's some things that, you know, sometimes you just can't solve for X, and I think this is one of those things where you're just not going to be able to solve for X, unfortunately. Let's go to Florida. Wade Mercer's doing his first appearances.
Well, history, is that accurate, ma'am?
Yes, sir.
And how old are you, Miss McMillan?
Sir,
How old are you?
I'm 33.
You live in the Chattahoochee area?
Yes, sir. That's my mother's main address that I normally use. I rent from Sneeze, Florida.
Okay. Ms. McMillan, I'm going to let you pick. Let me make sure the attorneys don't have any additional information before I make that final decision. Mr. Mitchell, anything on behalf of the state?
No, Your Honor.
Mr. McDaniel, anything on behalf of Ms. McMillan?
Girl, we just asked for some kind of cash bond. She's local, strong ties, no criminal history. She'll be here for a hearing.
Sure.
Her employer came in, not yesterday, but the day before. And she was under the assumption they were going to pick her up Wednesday. She'd be at first appearance is Thursday, so she wasn't. But anyways, her employer said she was trying to pay the restitution amount at that point. I told her she couldn't, but that might be a possibility. So I'm not saying you need to set a cash bond, but the employer is going to post it if you do.
All right, thank you. Mr. Mitchell, any objection to a cash bond?
No objection.
Ms. McMillan, if I'm going to set you a cash bond, I have no problem doing that. The state's not opposed to it. It'd be $500 cash. I am going to offer you a conditional release because of your criminal history. If you prefer the conditional release, that's okay too. But your cash bond is $500 cash. That's in lieu of a $5,000 surety bond, which is normally what this charge would carry. So if you want to accept the conditional release, that's fine. If you want to accept the cash bond, that's fine. Either way, you will have a special condition to have no contact with the business that was involved in this rental agreement. Do you have any questions about your choice between the cash bond and the conditional release, ma'am?
Yes, sir.
I answered.
Where's that at?
Judge, she just asked for conditional release.
Ms. McMillan, what's going to happen next then is they're going to let you use the phone and let you get dressed in your regular clothes, ma'am. The reason for using the phone is in case you want to set up transportation. And if you do, ma'am, they'll let you use that phone. You need to call friends or family, or if you do call friends or family, you can tell them that you can be picked up at the Jackson County Courthouse in 30 to 45 minutes, ma'am. That's where you need to be picked up, not at the jail, at the courthouse. The jail will bring you to the courthouse to meet with a conditional release officer. Ms. McMillan, do you have any questions?
No, sir. I think you guys answered all. Quick question. So they don't want the property. I just need to go ahead and pay for everything?
No, you don't need to do anything till you talk to an attorney. That's my suggestion. Okay, talk to an attorney before you do anything. Okay.
Yes, sir. Thank you so much.
Have a good day, man. I've got Berenstein Hardison, but I think there's a typo in that name. Miss Hardison, good morning. Miss Hardison, you're here for first appearance, ma'am. And I think the complaint is wrong. The complaint is Berenstein, Berestine. You have an extremely lengthy criminal history, but your criminal history is under the name Bernstein with two N's in your first name.
Yeah, that's the right one.
Okay, so I need to make sure that the jail records, it should be Bernstine, correct?
Bernestine.
Okay. Bernes. So, Corporal, it's not the jail's error, it's the charging agency or officer's error. So it's messed up from the beginning. So I need the jail to reflect the AKA as well as the clerk's office to show the correct spelling. So, Ms. Hardison, when I found out your correct spelling, that led me to your criminal history, which is not good at all. Looks like you've been to prison 3 times, I believe, ma'am, and you're accused of 1 count of introduction of contraband and 1 count of possession of synthetic cannabinoids. I think you're entitled to a bond. Ma'am, Ms. Hardison, let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell, anything?
Just that she be subject to random UAs.
Ms. Hardison, I'm going to set your bond at $7,500 per count because your criminal history is so bad, ma'am. Your total bond today is $15,000. Ma'am, that's cash or surety. You have 2 special conditions. One is to have no contact with any Department of Corrections property. You cannot go to any Department of Corrections property as a condition of your bond. And secondly, you are subject to random urinalysis because of the allegations against you. Ms. Hardison, you will get to use the phone in just a few minutes, ma'am, to try to post that bond. Do you have any questions?
No, sir. 15.
Right.
I gotta have 15.
We have Joshua Paramore next. Mr. Paramore, good morning. Mr. Paramore, you're here because you've been accused of 1 count of battery, domestic violence. Mr. Paramore, I read the complaint. There is probable cause. The only thing I saw in your criminal history was 1 prior battery involving your brother. That's the only thing I see. Mr. Paramore, you don't have any charges pending anywhere, do you?
No, sir.
Okay. Are you working, sir?
Yes, sir.
And the alleged victim in this case is Miss Dean. Do you and Miss Dean reside together or do you have separate residences?
Together.
Okay. Do you have somewhere else you can live on a temporary basis other than the residence that she lives at?
Yeah, I can live with my brother, Scotty Rowan.
Okay. Let me see if the attorneys have any additional information. Mr. McDaniel, anything?
Your Honor, we just asked for a conditional release, maybe. He only has 1 disorderly conduct charge in the past, and yeah, there's a fight between his brother.
All right, Mr. Mitchell, anything?
No, Your Honor.
Mr. Paramore, I'm gonna let you pick between a bond and a conditional release. Your history is not bad. The bond option is $2,500 if you prefer that. The conditional release is also an option. Either way, you would have a condition to have no contact with the alleged victim at all while this case is pending. If you and she both want contact, I'd consider that at a later date, but right now, no contact. That means you can't live there as long as she's living there. Mr. Paramore, any questions about your choice between bond and release?
No, sir.
And which you prefer?
Release.
I'm gonna grant you the conditional release. Mr. Paramore, the other thing we're gonna do is when you get here, I'm gonna ask the conditional release office to give you a written notice and get you to sign for it for your next court date. And when would that be, Dottie? July 28th will be your arraignment date. Mr. Paramore, they'll give you that notice. You will not get a notice in the mail. The one they put in your hand before you leave the courthouse will be the only notice you get. So make sure you keep up with that. Mr. Paramore, do you have any questions?
No, sir.
Have a good day, sir. I apologize. Let me go to Mr. Thomas. I try to take people that have friends or family here first. Mr. Thomas in the courtroom. I just forgot. Mr. Mitchell reminded me, and I still forgot. Mr. Thomas, good morning. Mr. Thomas, you're here for first appearance accused of 1 count of battery domestic violence. Mr. Thomas, there is probable cause for the case, the charge against you. Your father is in the courtroom, Mr. Thomas. And Mr. Thomas, you have no prior criminal history at all, as far as I can tell. Is that right, Mr. Thomas?
Yes, sir.
All right, so Mr. Thomas, let me see if the attorneys have any additional information, then we're going to address bond or release. Mr. McDaniel, anything?
Your Honor, we just asked for a cash bond.
Mr. Mitchell?
Your Honor, I was speaking to his father earlier today. He may have some more information regarding this case. I don't know if you want to speak to him on the record or wait till afterwards.
Well, I can't talk to him afterwards because Mr. McDaniel's not here. Well, actually, I could if, as long as we weren't on Zoom. So I don't know what the information is.
I was before you, sir, Wednesday.
On the writ of replevin?
Right.
You want him to come up to the mic?
Yeah, I want to make sure your son can hear you, Mr. Thomas. So if you come up here, that way we'll make sure he can hear what everything you say. So was it a writ of replevin? It wasn't an eviction. It was another type
It
case.
was a unlawful detainer.
Unlawful detainer. They didn't show up. I granted it. But you really didn't want your son out. You wanted the girlfriend out, which is
Yes.
the alleged victim in this case. But you asked for a couple of weeks to give them time.
Yes, sir.
And I explained to you that getting her out when he still had permission to invite her back was kind of a waste of time. And you elected to say, if that's the only choice I got, I need to have them both gone then. So since then, this all happened, which doesn't involve you, it involves him and her, correct?
Yes, sir.
Okay, I'm with you.
I mean, I was actually watching while all this was going on. They were in a car in my yard. And I could see the flailing and the slanging and the screaming and the hollering. So, and it's not the first time this has happened.
Okay.
But my wife just let me know that her father and her and a deputy sheriff are at my house right now, getting her stuff out of my house. So I'm not sure if you need to readdress the 2-week.
I can't today because we're here on the criminal case. I can't modify a civil case without giving all the parties notice of it. So I don't have authority to do that. What I do have authority to do is he's going to have a condition of no contact with her. So the question is, now that you know that condition is going to be in place, assuming she's gone from your home, do you have a problem with him coming back to the home?
I do not.
Okay.
And I prefer him to be at my house.
Okay. So Mr. Thomas, one of the questions before I started this whole process is whether or not you have a place to live, because if she's in that home, you can't go there. Because I'm going to have no contact between you and she, which is actually an order I have to follow from the chief judge in domestic cases, at least initially. There's no contact at all between you and her. Now that includes telephonic contact, computer contact, digital contact, carrier pigeons. It includes everything. No contact at all with her. So the question is, knowing that you're going to have no contact with her, you need to also understand if she's gone from the home, you were in your parents' home, correct, Mr. Thomas?
Yes.
You were in your father's home with her. So if she's gone, you can reside there. If you get out of jail and she's still there, you cannot live there. You have to find somewhere else to go. Knowing all of that, do you want to go back to that home as long as she's gone, Mr. Robert Thomas? It's not a trick question. Either you want to go back to that home or you don't. I'm not trying to mislead you or trick you. I'm glad to set you a bond, but I'm not going to give you a conditional release if you don't have somewhere to go.
Question.
Yes, sir.
Yes, you do want to go there, right?
Yes, sir.
Okay. So what I'm going to do is this. Mr. McDaniel, you're requesting a cash bond as opposed to a conditional release. Is that what I heard you say?
Yes, Your Honor.
Mr. Mitchell, any objection to that?
No objection.
Same choice as the last person. I always give the conditional release as an option. If you prefer the cash bond, because this is a misdemeanor charge, your cash bond will be $250. If you want to accept the conditional release, I'm going to offer the conditional release. Either way, you will have a condition of no contact with the alleged victim, Mr. Thomas, no contact at all. And knowing all of that, you want to post the cash bond, or do you want to accept the conditional release?
Are you done?
I don't think he understands, sir. The conditional release would be my choice.
Mr. Thomas.
The cash bond, sir.
Okay. So you've got a $250 cash bond. When that's posted, you'll be released. If you change your mind and you decide to accept the conditional release, let the jail know that immediately after first appearance. So what, Mr. Thomas, in the courtroom, what that means is the cash bond has fewer rules to follow. Some people prefer a cash bond. The good thing about a cash bond, and the reason Mr. McDaniel requested, is the money's not wasted. It's not just spent on waste is not the right term. Bondsmen provide a valuable service, but if you pay money to a bondsman, they keep that as their fee. If you do a cash bond, that money goes to the clerk's office, and the clerk's office just holds it. If the case is dismissed, it's returned to whoever posted it. If it's not dismissed, that cash bond goes towards court costs and fines.
Okay.
So some people prefer a cash bond because a cash bond doesn't have as many rules to follow as a conditional release office.
That would be
Conditional release
fine,
officer.
sir.
He doesn't have to check in once a week by phone. He's not subject to your analysis. So there's less rules to follow.
Okay.
So he's chosen the cash bond of $250 at this point. When that cash bond is posted, he can be released. He's welcome to go to your home as long as she's not there.
Okay.
If she comes there, it's kind of strange a little bit, but she can't get in trouble. He can. In fact, if I'm aware of them having contact in violation of a court order, then I would issue a warrant for a violation of conditional release, which usually has no bond on it. So I need everybody to understand they make up 2 days from now. There's a process she has to go through to allow contact. And, obviously there's already a signed order in the other case.
Okay.
Mr. Robert Thomas, do you have any questions, sir?
No, sir.
And Mr. Thomas in the courtroom, do you have any questions?
No, sir, we're going with the bond, correct?
That's what he has decided.
So what do I do? Go to the bank, get cash money, or?
$250 cash goes to the jail and he's released
Okay, I go to the jail.
with $250 cash.
Okay,
Yep. Any other questions?
no, sir.
All right. So Mr. Robert Thomas, I think your dad's going to try to get that bond posted. Since that bond is posted, you'll be released. Just have no contact with her till this thing simmers down, and we'll cross that bridge if we get to it. If both of you want contact, I'll consider it. But obviously, you're not going to be in that residence even if you want contact. Okay, sir?
Yes, sir.
Have a good day. Thank you for coming, Mr. Thomas.
All right, so just go get cash, go to the jail.
He'll be released.
I
Yes, sir.
appreciate it.
Yes, sir. And if she's still there, he doesn't need to go there now until she's got all her stuff and she's out of there. Okay. Yeah, I guess you'll know when you can leave here. You can call your wife or whatever. Okay. Yes, sir. After Mr. Thomas, I believe we are at Antonio Gray as well as Sterling Crumpler. Mr. Gray, good morning. Mr. Crumpler, good morning. I'm seeing at the same time because your cases are identical for first appearance purposes. Each of you are accused of violating the terms of your state probation or community control. In each case, the circuit judge has signed a no bond warrant. What I'm going to do this morning is I want to go ahead and get you arraigned. But before I do that, I need to make sure. So, Corporal, in Mr. Gray's case, I know the warrant has been served. I do not know if the warrant's been served in Mr. Crumpler's case. Corporal, has that warrant been served yet?
No, Your Honor.
Okay, so Sergeant Applewhite, if you'd please get the Sheriff's Department to notify them that Mr. Crumpler's in jail. There's a BOP warrant that's been signed a couple of days ago. It needs to be served. So, Mr.
He said
Crumpler,
they
did you
served-
serve your warrant.
Mr. Crumpler's telling me they served it on him yesterday.
Yeah. We don't have it, Your Honor.
It's not in the first appearance packet, so I'm not sure if it has been served. Sergeant Applewhite, we need to make sure they get a copy to the jail so the jail can get it to the clerk's office. And 3 different case numbers, but I don't know if there's 1 warrant or 3 warrants, but we'll have to let them figure that out. So let me get you arraigned. Mr. Crumpler, would you like to have an attorney appointed to represent you?
Yes, sir.
Mr. Gray, would you like to have an attorney appointed to represent you?
Yes, Your Honor.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent both of you. Listen to Mr. McDaniel, then we'll see if either of you have any questions.
Your Honor, we're going to enter a plea of not guilty. Yes, to set this in the August 21st court docket, and I advise them Sabrina to come by and speak to them prior to those hearings.
Thank you, Mr. McDaniel. Mr. Gray, do you have any questions about any of that, sir?
No, Your Honor.
Wish you the best. Mr. Crumpler, do you have any questions?
No, sir.
Wish you the best also. That brings us to Julian Sanders.
I'll tell you after.
Your Honor, can I go ahead and do him last?
Sure. We'll come back to Mr. Sanders then. That brings us to Aaron Summerlin. Mr. Summerlin, good morning. You're here for first appearance accused of 1 count of battery domestic violence. There is probable cause in the complaint. When I looked at your criminal history, it appeared you had a very recent DUI charge. So I took a closer look at that. It looks like you've got out of jail within the last few months. So, Mr. Summerlin, I'm going to set you a bond in this case, but let me see if the attorneys have any additional information that they want me to be aware of before I set that bond. Mr. Summerlin, Mr. McDaniel, anything on behalf of Mr. Summerlin?
No, Your Honor.
Mr. Mitchell?
Your Honor, I guess we would just request the court take into account that he has a 2015 DV battery in which he was adjudicated guilty for. So we just request a reasonable bond under those circumstances.
This is filed as a misdemeanor, correct?
Yes.
Or I guess.
I'll review it and see if we can transfer it up,
But
but
right now it's a misdemeanor.
but
right?
right now
For
it's a
bond
misdemeanor.
purposes.
Yes.
All right. So, Mr. Summerlin, I'm going to set you a standard first degree misdemeanor bond at this point. That may or may not change depending on what the state does, but your bond's $2,500 cash or surety. Mr. Summerlin, your bond has a condition of no contact with the alleged victim. You will get to use the phone in just a few minutes, sir, to try to post the bond. Do you have any questions, Mr. Summerlin?
No, sir. Good luck to you.
Have a good day, sir. Cindy Whitman. Ms. Whitman, good morning. Ms. Whitman, you're here for first appearance. You're also accused of driving under the influence. I say also, that's not correct because you're the first one on the docket today. You're accused of driving under the influence, Ms. Whitman. There is probable cause in the complaint, and you do have a lengthy criminal history. Ms. Whitman, I'm going to appoint the public defender's officer to represent you for first appearance purposes. And I want to listen to Mr. McDaniel before we see if I need to set a bond, if there's some type of agreement that's been reached. Mr. McDaniel?
Your Honor, we just asked for a reasonable bond.
Thank you. Mr. Mitchell?
No objection, nothing from the state.
Ms. Whitman, I'm going to set you the standard bond for DUI when I don't offer conditional release. I'm not offering you a conditional release because you have 2 older DUIs and your criminal history since then is not good. Ma'am, your bond's going to be $2,500 cash or surety. The question I have is whether or not there's going to be a condition of no driving or not. Mr. Mitchell and Mr. McDaniel. Let me take a look at the complaint again, because there was one thing that it's confusing because it looks like the trooper uses some kind of form. The reason I say that is because he says he was involved in a traffic crash when it's obviously a she. And then he says in one part, there is no alcoholic beverage, that it's some other kind of medication or substance. And then there's one sentence that says the defendant is under the influence of an alcoholic beverage. There's no mention of any alcohol, no mention of anything except that one sentence. So I'm not sure if it's an alcohol related. Let me finish, Mr. McDaniel. Wait just a second. I'm not sure if there is if it's accused of an alcoholic DUI or not. So I'd like to get y'all's input on that. Mr. McDaniel?
I thought it was it was, I thought the report was filled with conclusory opinions without any facts in it. When I read it, I was kind of shocked that the FHP officer wrote that. I didn't see much in it, but I clearly see this, I kind of guessed what he was trying to say, but I didn't see much in there except that I think statements like she was clearly under the influence or something, but there was nothing showing why she was under the influence or anything, or what that was. And there was nothing in there about any kind of DUI test, whether she refused those tests. I thought it was kind of unusual, I thought, for an FHP trooper to write a report like that.
Mr. McDaniel, I think you're exactly right. When I read it, I was thinking about whether or not there's probable cause because of what you just said. But here's what I kind of hang my hat on for probable cause purposes. There's a couple of sentences that say, observed Ms. Whitman was unsteady on her feet, had difficulty remaining on task, causing her to repeat myself multiple times, fumbling with paperwork, difficulties opening and closing the vehicle doors, including the glove box. Ms. Whitman appeared to be under the influence of a drug of some kind and did not appear to have control of her normal faculties. So I thought that was enough for probable cause coupled with a crash. But the problem is he never mentions alcohol. And then later on, there's that one sentence. So I think he was copying and pasting off of an old complaint, and there's no alcohol alleged. So I'm not going to put a condition of alcohol. Actually, that's the condition of any DUI bond. But my question is whether or not she has a driver's license.
It was valid this morning, but I don't know if the officer took it. But if he did not take it, it won't be valid but for 10 days until they get suspended.
Thank you. So what I would do is I would have a condition of your bond that you do not drive a motor vehicle unless you have a valid license. I'm a little unclear whether you have a valid license. Just a second, I'll give you a chance to ask questions, Ms. Whitman. If you have a valid license, you certainly can drive all you want. But if you don't have a valid license, you cannot drive a motor vehicle. That's a condition of your bond. Did I get to the point of setting a bond?
2.5.
Yeah, it's a standard $2,500 bond for DUI. No alcohol, no drugs without a prescription, and no driving unless you have a valid license. Now, I think you may have a question. Don't talk about the charge against you, ma'am. We are being recorded. But if you have a question, and if it's a question I can answer, I will try. Any questions?
Okay, I explained to that officer when I was there. I felt 2 years.
Anyway, she's talking about.
Any questions, ma'am?
No.
All right, wish you the best, ma'am. You'll get, use the phone shortly.
Thank you, sir.
Try to post the bond. Yes, ma'am.
Your Honor, I got Damian Justin, case number 25364 CT.
Okay, I got some thanks to dole out. First, thank you, Ashley, for gifting 10 memberships. Very much appreciated. Winks, Kiwi TV, Scottish Paula, Jennifer Elizabeth Turner, Elizabeth Tucker, Devin Max, Here Comes Drama. That one should fit interestingly with us. Laffy Leo, Mike Long, and Tony 2A. You are now all channel members. Thanks to Ashley. If you're lurking out there, please do thank her in the chat. And Barbara, thank you for the $5 super chat. Very much appreciated. You guys just continue to amaze me. You're all so very kind. It never goes unnoticed. I hope you know that. Let's get back to Judge.
That agreement?
Yes, sir, Your Honor.
Do you have any questions about that agreement?
Oh, no, sir. I'm trying to get back and get out of here, sir. That's all.
Okay, so is this a plea you would like to enter?
Yes, sir, Your Honor.
Question? Guilty. Thank you. Mr. Justin, I'm going to accept your plea of no contest in case 25364 CT, but it wasn't to drive my license suspended. It was to an amended charge. I think Mr. McDaniel said a no valid driver's license.
Yeah, no objection to that.
So it'll be to no valid driver's license. Mr. Mitchell, the plea is agreeable with the state.
Yes.
I judge you guilty of that offense, sentence you to 60 days in jail. You got credit for 5 days you've already served. Sir, court costs and fines of $400 are imposed, but hopefully you'll get those worked off at the jail. There's no probation involved in this sentence. We need to make sure that reflects the no valid driver's license. Do you have any questions, sir?
No, sir, Your Honor.
Wish you the best.
Yes, sir. Thank you.
Then we have Julian Sanders. Mr. Sanders, good morning. Mr. Sanders, you're here because you've been accused of violating the terms of your probation in case 22-65 CT. It looks like we've had a warrant out for you for almost 3 years. Mr. Sanders, I'm going to appoint the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney, sir.
Your Honor, I spoke to Mr. Sanders in case number 2265 CT. He's going to plead of no contest to the charge, to the violation of county probation. And we're going to open sentence and let him speak to the court.
Good morning, y'all.
Hey, good morning, Mr. Sanders. Let me ask you a few questions. I'll be glad to listen to anything that you think is relevant that you want to tell me. Mr. Sanders, you understand you're accused of violating the terms of your probation in that case number. It's a first-degree misdemeanor. Mr. Sanders, you've got a couple of choices. You do have the right to go to a hearing. Mr. Sanders, I have to explain to you this. If you want to exercise that right and go to a violation of probation hearing, one will be set in the very near future. At that hearing, you're entitled to counsel. However, you also have the right to waive that hearing. If you waive that hearing, there will not be a hearing. You'll be admitting to the violation of probation, admitting that you violated the terms and conditions of your probation. I'll listen to you. I'll listen to the state, and I will then sentence you accordingly. You understand if you enter this plea, you're waiving all those rights. You understand all that?
Yes, sir.
Mr. Sanders, is that what you want to do?
Yes, sir.
Okay, so I'm going to accept your admission that you violated the terms and conditions of your probation in 22-65 CT. You're on probation for first-degree misdemeanor, driving while license suspended or revoked knowingly. And the allegations are you got multiple new charges in Washington and Holmes County. The second allegation is financial. The third allegation is financial. And the fourth one is that after you got the charges in the other counties, you stopped reporting. That's essentially what you're accused of in the affidavit. So anything you want to tell me, I'm glad to listen.
Judge, before he talks, I'll just let the court know that, I guess he got arrested in Holmes County shortly after he went on probation. He ended up going to prison. I think he may have got out of prison, if I recall, maybe April or May of this.
May 28th.
Was this year?
Yes, sir.
May of this year. So he's been in prison since 2022, and I'll let him say whatever, he wants to say.
I didn't realize that. So let me ask a question about that. I knew that he got charges, but I thought he was kind of essentially on the run. So what it sounds like is you got sentenced to prison in one county, but not the other. Is that right, Mr. Sanders?
Yes, sir.
So the whole time you were in prison, you had this hold on you or a detainer or whatever. And you also had a detainer from a second county, which was what, Washington County?
Yes, sir.
The county you went to prison in is Holmes County, correct?
Yes, sir. Yes, sir.
Okay. And then when you got out of prison, they had a detainer on you. They shipped you straight from prison to Washington County to resolve that hold?
Yes, sir. They gave me 30 days time, sir. Monday
Okay,
on the
that
7th.
changes things significantly. That's a lot different. And Mr. McDaniel, thank you for pointing that out.
I apologize. I thought I probably should have clarified that this morning. I apologize.
I didn't, I knew about the charge, but I thought he just got the charge and just disappeared from probation because he had a new charge. I didn't realize he was in prison. And I just didn't catch that. So Mr. Sanders, I'm gonna listen to Mr. Mitchell, but before I do that, anything else that you want to make sure we're aware of?
Just my kids, Your Honor. I have support behind me. My church family, they got me set up with a job. I'm trying to get out and do the right thing, Your Honor. If you can have a little leniency on me, I appreciate it. My children are 10 and 8, and they're currently, their grandmother currently have custody of them, which on November 1st of 22, I was given some paperwork from a case manager out of Georgia, indicating that I was next up to get custody of my kids. But I had to go resolve this issue. So they've been with their grandma that's 70+ years old for 3 years now. They waiting on me, Your Honor. Can you help me out?
All right, let me listen to Mr. Mitchell, and then I have a question about how much credit you have. Mr. Mitchell.
Your Honor, I just wanted to back up what he was saying about being in prison. I'm looking at the DOC website. He did go to prison in May of 2023, and he was just released May 28th of this year.
Okay. All right, thank you. Mr. McDaniel, how much credit does Mr. Sanders have on this case?
He just has 1 day, Your Honor. This was a walk-in complaint that he went on probation for. So he has 1 day from yesterday.
All right, Mr. Sanders, what I'm going to do is I've already accepted your plea of no contest. Given everything that you've told me and I've filled in the gaps, that's going to change what your recommended offer substantially. I think the recommended offer initially was 9 months in jail. Based upon what I'm hearing now, I'm going to sentence you to 10 days in jail, give you credit for the 1 day you've served. There was a different sentence. I get that, but also you paid your debt to society for the other offenses, so I'm not going to consider those. So we're just going to say a 10-day jail sentence, 1 day credit. You finish in 9 days. This is all over with. No further probation in Jackson County. No further sentence in Jackson County that I'm aware of in any case. And you'll be released when you finish that sentence. There are remaining court costs and fines I have to convert to a civil judgment, and those are the amount of $400. So you finish the 9 days, you'll be released. I know that you're trying to get your life back on track. You need to understand that if you don't pay that $400 within 90 days of your release date, or enter into a payment plan with the clerk's office, then by law, the clerk's office has to suspend your driver's license privileges. So when you get out in 9 days or so, you may want to contact the clerk's office and get on some kind of payment plan for that $400. And they're very, I think the payment plan can be as low as $10 a month or something like that. Is that, what is it? Within 1 year. So that's actually, yeah, it's less than $10 a month. No, it's not. My math is not very good. It's about $30 a month, 35. All right. So Mr. Sanders, you finished the sentence. You're through with this case. Do you have any questions, sir?
How would I make who would I make the payment to? Would I bring it to the clerk, to the Jackson County
Yes, sir.
courthouse?
You contact the Jackson County Clerk of Court when you get out.
Okay. Yes, sir.
Okay. Have a good
Thank
day,
you, sir.
You're welcome. Yes, adjudicate guilty.
Okay, it's time to change things up a little bit. Let's go to Bexar County and say good morning to Judge Boyd.
4056 State versus Kenneth Wayne Howie. Could I have parties announced?
Your Honor, Dorian Kotler, District Attorney Pro Tem with the Office of the Attorney General.
Louis Martinez on behalf of Mr. Howie.
All right, and are you Mr. Howie?
Yes, ma'am.
All right, defense, do you have any objection to the OAG appearing by Zoom?
None, Judge.
Mr. Howie, do you have any objections?
No, ma'am.
All right, so 2018 CR 4056 is the motion to revoke. The defendant has not entered a plea to the allegations in the motion to revoke. As all parties are aware, this is the case where we've been trying to find placement for Mr. Howie. So placement has been found. It's at Cross Point. It's the court's understanding that Cross Point will transport him from the Bear County Jail to the facility. To Mr. Coulter, did you receive the court's email, which was done without objection from the defense, of the letter or email from Cross Point stating that Mr. Howie had been accepted into their program?
I did, Your Honor.
All right. So with regards to the motion to revoke, Attorney Coulter and Attorney Perez, if you'll make your announcement for the record, please, as well. You're on mute.
Sorry, Judge. Aurora Perez, representing the state of Texas with the Texas Attorney General's office.
All right. So with regards to the motion to revoke, Attorney Coulter, are you asking that the motion be withdrawn?
I am, Your Honor.
All right. Any objection to the withdrawal of the motion? All right. The court will again note for the record that the OAG is by Zoom and they are unable to sign the motion to withdraw. Any objection from the OAG or from the defense of the court writing on the signature line that OAG by Zoom unable to sign?
No, Your Honor.
None for the defense, Judge.
All right, then the court will sign the motion to withdraw. And also in regards to this case, it is the court's understanding that both parties have agreed to extend Mr. Howie's probation for 2 years. Is that correct, State?
Yes, Your Honor.
Defense, is that correct?
That's correct, Judge.
Mr. Howie, do you understand that your probation will be extended for 2 years?
Yes, ma'am.
Any objections from you, Mr. Howie, to your probation being extended for 2 years? Also, he is going to be alternate amended to include placement at Cross Point. It's the court's understanding that Cross Point will transport him from the Bear County Jail to the location. To the OAG, any objection to his probation being alternate amended to include placement at Cross Point?
No, Your Honor.
Any objections, defense?
No, Your Honor.
Mr. Howie, do you have any objection? All right, then the court has signed the motion to withdraw. Your probation will be extended for 2 years. You're going to be placed at Cross Point. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Everybody is trying to get you the help that you need. You need to make sure that you stay on your medications. I understand sometimes medications have side effects, but that's where you talk to your doctor and let them know. And you cannot disappear. If you leave Cross Point, what's going to end up happening, if you leave it without their permission, I'm going to get notice. I'm going to receive another motion to revoke. Do you understand?
Yes, ma'am.
Do you have any questions about anything?
No, ma'am.
All right. Then the next case we need to take up is (2025) CR 001600. To the OG, is it your intention to dismiss that case?
Yes, Your Honor. We will be submitting that shortly after this hearing.
Any objections to the dismissal?
No, Judge.
All right, once the court receives the dismissal, the court will sign it. They're not going to take you until I receive that dismissal and I sign it. So as soon as I receive it and they're telling me that they're going to have that done shortly, you'll be good to go.
And Judge, we are agreeing to the 2-year extension. If Mr. Howie is doing well, does well at Cross Point, because right now he is on probation until October 26th. So that would put him on probation until October of 28. At what point would the court be willing to review him to maybe cut him pretty early?
Well, let's just, I always say I don't like to build bridges until you're ready to cross the river. So let's see how things are going at Cross Point. What I can tell you, Mr. Howie, in this court, if someone is seeking early termination, usually probation will send me an email and tell me, we would like this person to be released off probation early. What I can tell you is anytime I receive requests for early termination, I will always send it to whomever is the state. In this case, I would send it to the OG and AOG and see if they have any objections to that. And if they don't have any objections to it, then normally I will sign it. If they do have objections to it, then we will have a hearing. Okay?
Understandable.
And I know that's a non-answer to your question, but that's the best I can give you.
And I appreciate the court telling us the protocol the court would use to consider that. So I do appreciate that.
All right. Is there anything else?
Nothing from the state.
Nothing from the state, other than I appreciate everybody's effort to get this resolved, and yeah, and as far as we just wanted him to stay in his medication. Nobody's trying to, Mr. Howie, nobody's trying to jack you up. The last thing we want to do is for you to go to the penitentiary. So
thank you very much. And I understand, and I'm not making an excuse. It's more of an explanation. I am seeing a psychiatrist in the world, and I was trying a supplemental medication other than Xanax that I had a bad reaction to. Some of that made me violent.
Okay.
And that's going to be rectified when I get out. His name is Dr. Ali, for the court record, a psychiatrist. I can provide more information if need be, to where he's going to go back and prescribe me the original deal.
All right. Well, just make sure that you let probation know who your psychiatrist is, because they'll need that information as well.
Yes.
And again, talk to your doctor. And if you feel as though I'm not a doctor, right?
Right.
A medical doctor, at least. We're all have our doctorates. Our parents love to say, my baby's a doctor, not that kind of doctor, right?
Yeah, if we're on an airplane and they need a doctor, we're of no use.
We're
So
no
let's be
use
very clear about
unless we're George Costanza.
Right.
So, but you've seen that episode, right?
Oh my gosh, that's awesome.
And then when he's on the beach with the whale.
The whale. I was going to say the whale when he.
Yeah. Somebody sent me something and it's cans of soda. And so one of the sodas is losing a lot of sodas. And they're like, Dr. Pepper, you need to do something. And Dr. Pepper above his, it says, is now the time I can tell them I'm a doctor of deliciousness. So here's the thing. You need to let your doctor know, okay?
Yes, ma'am, I will.
And if there's anything that's happening that you have issues about, let probation know.
Yes,
Usually in this court, things are set for compliance hearings so we can see what's going on.
Real quick, you said Crosspoint is going to be picking me up from Bear County facility.
Yes.
It is a process to get released from Bear County.
Oh, no, that's going to be done now. As soon as I get that dismissal, there's nothing that's going to be holding you.
Oh, and they haven't opened up.
Yes.
Okay.
Yeah, we're getting an email that been for you right now.
Okay,
So that's why
thank
we
you.
get you the right.
Thank
Yes.
you so much.
And to the OAG, thank you all for coming in on short notice. We just received yesterday that they had the bunk available. And if you don't move quickly, those spaces will be lost.
Not a problem. Thank you all so much. Y'all been wonderful.
All right. Thank you, guys.
Thank you.
Doesn't that sound like doesn't that sound like a movie? Yeah. Thank you, guys.
Thank you.
All right, bye. Have a good one.
Take care. Thanks, Judge.
Thank you.
You always have a nice bouquet of flowers, arrangements.
Well, my mom always tells me that the most time you spend in your life is either at work or at your home. And you should always try to make work as beautiful as possible.
Would it be out of line if we're not allowed to send you a bouquet of flowers?
Well, I tell you what, if you want to send the staff flowers, you can send the staff flowers.
To this court?
Sure, you can.
Okay, thank you.
All right.
When voting comes up,
Oh,
me, my friends and family,
okay, so yeah, thank you. All right.
Recusing myself.
I'm not allowed to do those type of things from the bench.
Oh.
Yeah. I appreciate you
Thank you,
though.
Miss Hollywood.
That's not who I am.
So yeah, she's in a good mood. So here's what we're going to do. I'm dropping a poll in the chat here in just a moment, and I want your feedback because you have a choice to make. I am currently looking at a preliminary exam type of hearing in Judge Webster's court. It looks interesting because it looks like there's body cam, it looks like there's dash cam, and it looks like we can see it all. And there's audio from it and everything, so that's pretty cool. But if we go there, we'll be there for at least an hour from the looks of it. So you guys make the choice. Do you want to spend an hour in Judge Webster's court and see what that's all about? Because there's actually, like, it looks like interesting content there. Or would you prefer for me to keep rotating through different courts? We'll give you a few minutes to decide that. And in the meantime, let's go from happy to grumpy, and we'll spend a few minutes with Grumpy Pants.
And he sold 43 grams of cocaine. And then there's a warrant July 10th yesterday.
Y vendió 43 gramos de cocaína. Hay otro a orden de ayer.
It looks like the confidential informant was trying to purchase an ounce of cocaine in exchange for $1,200.
Y luce también como el informante confidente estaba tratando de negociar para comprar una onza de cocaína por $1,200.
Like they filed one charge of trafficking for all of them.
Okay.
Aparentemente presentaron un caso de traficar para todo.
All right.
Separate possession of cocaine.
Bien.
Count one. There's probable cause for trafficking in cocaine. That
Cargo.
bond is,
Go ahead.
that bond will be $25,000.
Cargo 1, hay motivo fundado para traficar cocaína. Esa fianza va a ser $25,000.
1 minute.
Minuto.
So they entered his home and after the search warrant, they also recovered 19 grams of cocaine.
Entraron a la casa después que tenían la orden de pesquisa. También recuperaron 19 gramos de cocaína.
Count two, possession of a place for purposes of trafficking in cocaine is $2,500.
Cargo 2, posesión de un sitio para traficar cocaína, $2,500.
Judge, what's count one?
Count one is $25,000. Count two is $2,500.
Thank you.
Cargo 1, 25,000. Cargo 2, 2,500.
Count three, possession of cocaine. It should be possession with intent to sell cocaine for that first sale. State.
Judge, they may not want to charge that if they don't want to disclose the CI. I think he's just.
Okay, fine. Count three, possession of cocaine is $2,500.
El cargo 3, posesión de cocaína, es $2,500 después que clarificó algo con la fiscal.
And count four, resisting an officer without violence is $500.
Y el cargo 4, resistir un oficial sin violencia, es $500 de fianza.
That's plus a nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
Eso es más el requisito de Nevia. Usted tiene que mostrar el dinero usado para pagar la fianza. Viene de un fondo que es legal.
State, you sure you want a nebia? It's before Judge Richard Hirsch. You're going to yell at me for doing a nebia.
I think he's got immigration issues. I think he illegally re-entered. So if your honor doesn't want to do the nebia, that's fine. I don't think.
I'm going to say no nebia because this judge particularly gets upset when I set him for small amounts. So no nebia. He's
no
free
va a
to
haber
bring it
nebia.
out. But
No hay
so-
nevia.
But you do have an immigration hold, so be mindful of that. Have a nice day.
Pero si tiene un aguante de migración, tenga eso en mente. Buen día.
Okay, crowd has spoken. You guys want to go spend some time with Judge Webster, so that is what we will do. Again, this is going to be at least an hour, maybe a little longer. So I think it'll be this, and then with the time remaining, probably Dungeon Court. But let's see what it's all about.
County Jail. Zoom with Counsel Christopher Ambers, Farvis Legal, appearing from a separate location this morning.
We are set for preliminary hearing on a number of felony charges. Are the parties ready to proceed? Ms. Gillette?
The state's ready to proceed. We have Officer Fisher here, Deputy Fisher. I don't know if Mr. Ambrose needed to have a breakout room with his client or not.
And Judge, if I could have just a really brief one, I met with him yesterday, but he left me a voicemail late last evening. So if I could have just a second with him, I'd appreciate it.
All right, that'd be fine. Missy?
Thank you, Judge.
You're welcome.
Okay, so obviously we are in the Wayback Machine here to do this, so we can probably push past that little pause.
I'll call Deputy
There you go.
Blake Fisher.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Very well, please proceed.
Could you please state your name for the record?
Deputy Blake D. Fisher
And how are you employed?
by the Greenwood County Sheriff's Office.
And were you on duty on Friday, May 23rd, 2025?
I was.
Trying to figure out why there's a slight echo in here, Judge, but I have to have my laptop on for the there we go. No, there's still an echo and I told it to turn on. How long have you been employed by the Greenwood County Sheriff's Office?
Since December of 2019.
And since December of 2019, have you had experience with traffic stops?
Since January of 2021, I have.
And since 2021, have you done numerous roadside stops?
I have.
And have you had training?
I have.
What kind of training have you had?
Standard field training.
And have you taken any special training courses for roadside?
Just standard.
Now, what brought you to the defendant in this matter?
I was dispatched to the report of an individual on the south side of US Highway 400 between the 320 and 325 mile marker, which are in Greenwood County. The male individual was attempting to flag vehicles down, so it was a motorist assist call.
Did you then respond to the motorist assist call?
I did, and I located the vehicle at the approximate 323 mile marker in Greenwood County.
And what did you observe when you got there?
I observed an African male individual who was later identified as Robert Williams exiting the front driver's seat of the vehicle and standing on the shoulder of the roadway.
And did you stop to see what was going on with the vehicle?
I did.
Is it common for you to go to stranded vehicles to provide safety on the highway?
It is.
And what do you do when you provide safety for the highway when there's a vehicle stranded on it?
Typically, I activate my emergency lights on my patrol vehicle to let other vehicles know that we're stopped on the side of the roadway.
Did you do that in this case?
I did.
Did you have a dash camera on and available during the stop?
I did.
And is it correct with any modifications or corrections to it?
It is correct as to my knowledge.
And it displays everything that happened during the time that you interacted with Mr. Williams and his occupants?
It does.
Your Honor, we would like to admit as State's Exhibit 1, the dash cam video of Deputy Blake Fisher's patrol vehicle.
Any objection to Exhibit 1 being admitted?
Not for preliminary hearing purposes, Your Honor.
States 1 exhibit is admitted.
Permission to share screen, Your Honor.
Granted.
Missy's gonna have to turn share screen on.
Okay, let's see if you would, please.
It should be on now.
Okay, I understand this is the dash cam video of the witness. Is that correct?
It is, Your Honor. I have to turn my sound off so I can turn the sound on for the video and we won't have feedback.
Okay.
Hey, Sheriff, I'm 23, 400 eastbound at the 323. It's gonna be, I believe, Colorado, X-ray David Edward 630. It might be Oregon. How you doing?
Sheriff 40 and 165, 1017.
Now, Deputy, what did you notice about the vehicle when you approached it?
There was 2 occupants in the rear seats of the vehicle. The rear seats looked to be folded down with the occupants laying across them.
Okay. And who were the occupants of the vehicle?
The co-defendant in this case, Jessica Heath, and her juvenile daughter.
And were the seatbelts available to the occupants?
They were not.
Besides the seats being folded down, was there anything else interesting about that back part of the vehicle?
I was able to smell the odor of marijuana coming from the vehicle based on my training and experience.
And were the occupants laying on top of anything?
They were laying on top of a mattress type thing that was across the entire rear portion of the vehicle.
And was the juvenile secured in any way?
She was not.
Did you at some point call for backup?
I did.
Okay. And after you called, did you continue to be independent in this matter?
I apologize, Jill. You're breaking up a little bit.
Did you continue to interact with the defendant in this matter?
I did.
All right, we'll continue the video, Your Honor. We paused at 144 and we're going to move on from there.
165.
And now, Deputy, the individual that was facing rear towards us, can you identify which occupant that was?
That would be the defendant, Robert Williams.
No, I mean in the vehicle.
Oh, that'd be Jessica Heath.
Ms. Gillette, did you indicate that we are supposed to see someone facing us?
Yes, Judge, I can back it up for you so you can see it again.
Okay.
You look carefully in the back glass, you'll be able to see a face.
1017.
Maybe.
165.
Now, Deputy, how soon did you smell the marijuana when you initiated this traffic stop?
I was actually able to smell it when I exited my patrol vehicle.
And what made you believe it was coming from the vehicle?
There was a slight breeze and the windows were down in the vehicle somewhat. So after smelling it, approaching the vehicle, I just confirmed my suspicions.
Real quick, I just gotta let my dispatcher know what's going on. 8, sure.
Go ahead.
It's gonna be Oregon X-ray David Edwards 630. I'll be having 3 out of the vehicle here in just a minute. Is 6 or 12 available?
No, 6 is 12, 1, 10, 7, 12 while ago.
10-4. Since I'm this close to Butler, you might see if they have a unit available. If not, F6 could start my way.
6, 10-4 direct.
Okay, Judge, we're stopping.
Judge, no! Ah! Why did they do that? Back to Grumpy Pants for a minute while I get my patience back. Sorry,
Set it at
guys.
50.
Obviously, I have no control over when a judge just pulls a video, and Judge just pulled a video. Well, it was fun while it lasted. Hang tight.
Next case is Roberto Medinilla, page 9.
He's in jail arraignment. Can we pass?
Sure. Alexis Herrera. You have Mr. Herrera?
Good morning, Mr. Herrera. Sir, you were arrested for a false imprisonment with a deadly weapon, aggravated assault with a deadly weapon, and criminal mischief. Sir, can you afford to hire an attorney?
No, I cannot.
All right, I will appoint the public defender's office for you.
Requesting a bond plus house arrest.
Was a roommate dispute over money, and I guess he grabbed a large pair of scissors sitting on the kitchen counter, yelling at the victim, pushing her around. He didn't strike her, but he pushed her against the walls, threatening her with the scissors. So she tries to escape. He blocked the exit, so I guess that's the false imprisonment. And victim was eventually able to escape through a back door. He jumped on the hood of the victim's vehicle as she's trying to escape, began stabbing at the windshield with the scissors that he was still holding, and created several cracks in the windshield. Victim was terrified and distraught, crying during the response. And he was also positively identified by the victim. Ms. Court, anything you wanted to say?
No, Judge, Mr. Herrera, understands that the alleged victim is no longer at the home.
No longer there.
All right, well, if the victim is still there, you're gonna have to find somewhere else to live, but if she's moved out, then you're okay. So no contact with the alleged victim, Aliyah Abashishi, no, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. So if she's living in the home, then you can only go there one time only with a police officer to retrieve your personal belongings. Do you understand the stay away order, sir?
I wanted to ask one simple question.
Before that, do you understand the stay away order? That you can't have any
Yes,
contact with the
I
victim?
totally understand the stay away order, correct? Yes.
Okay.
Thank you. Go ahead. What's your question?
Judge, Mr. Herrera is not sure he's gonna have any funds for a bond. He's asking if you'll consider house arrest as an alternate.
State's requesting a bond plus house arrest. This is violent. When the police tried to talk to him, they screamed, he was screaming, he wouldn't calm down. He's been on probation before. It was violated 3 times. I'm concerned for her safety.
This is somebody else's stuff.
Count 1, there should be probable cause for armed false imprisonment. I guess that's how they charged it.
Right.
If I'm adding house arrest, I can lower the bonds, all right? Count 1 will be 20, there's probable cause for count 1. I'll set it at $2,500. Count 2. There's probable cause for the charge aggravated assault with a deadly weapon. That's $5,000. And count 3 criminal mischief is $150. That's plus house arrest with a GPS monitor. It's going to be level 3 house arrest. I'm not going to do a curfew. It's plus bond plus house arrest, level 3. Sid, are you okay if I don't do a curfew? This did happen at 1 a.m, but it looks like.
He was living there at the time. It's okay, Judge.
Bond plus house arrest. Next is Larry Morrow on page 10. Added.
So again, apologies to everyone for that whole Judge Webster debacle. I felt comfortable going there because generally that court leaves up the videos for a few hours after. So I figured we would have time to catch the whole thing before they deleted it, but somebody on her staff was very quick with the trigger finger and totally messed it up. But I think you understood why I wanted to go there, or potentially if you guys wanted to, because, you know, we had the body cam video that was really easy to see in the dash cam, and it was worthwhile. But some things I can't control, that's one of them. Let's go back up to northern Michigan and spend a few minutes with Judge Elmore.
Mr. Duke is being escorted here in the courtroom. He's currently in pretrial custody. This is a final pretrial conference. Myself and counsel had that conference in chambers. Parties told me that they anticipate a resolution in both of these two files. Duke is now seated at the defense table with counsel. Ms. Carey, why don't you go ahead and begin to tell me what the pretrial agreements are, and again, begin with file 14040. Thank you.
My understanding is the defendant will plead guilty to count 1 in that file. The people will dismiss counts 2, 3, and individual offender 4 theories.
Mr. Terry, is that a complete accurate statement? That's it.
As well as the second subsequent.
Yeah, I got it. Thank you very much, Ms. Carey. I don't think you mentioned that, but I understood that. All right, and Ms. Carey, the agreement as to file ending in 4-1.
Understanding you will plead guilty to count 1 and count 3. And the people will dismiss count 2 and 4, and the habitual offender 4.
Mr. Carey, is that correct?
Yes, Your Honor. The second subsequent issue as well. Yes, Your Honor.
All right, Mr. Duke, is that what you wish to do today? Yes, Your Honor. Please raise your right hand as best as you can. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir? Yes, sir. You may lower your hand. All right, Mr. Duke, a highlight for you that you've just taken an oath to tell the truth. That means that everything you tell me today will be treated and accepted as the truth. I say it that way because sometimes people like to come back at sentencing, and when they don't like the recommendation or the sentence, try to say, well, I didn't really do it, I lied. Well, that would be called perjury. So make sure everything you tell me today is the truth, because that's how I'm going to treat it now and forever. All right, Mr. Duke, back on back here in the month of February of 2025, were you on probation or parole at that time? No, I wasn't. Were you on any bond pending any felony charges? No? No, sir. All right. In file 14040, there's an alleged date range of February 5th through February 18th of this year. Now, in that file, you are charged with 3 counts. Count 1. Delivery of the controlled substance methamphetamine. That is a felony punishable by up to 20 years and or up to $25,000. There are 2 potential sentencing enhancements. One is called a second or subsequent drug offender enhancement. That means within the discretion of the court at sentencing, that maximum punishment could be increased from up to 20 to up to 40 years, and from up to $25,000 up to $50,000. Or in the alternative, you could also be sentenced as a 4th habitual felony offender. That enhancement could, within the discretion of the court, increase the potential punishment from up to 10 years to up to life. However, if you plead guilty to that count 1, the prosecutor agrees to dismiss both of those potential sentencing enhancements. Count 2 is another charge of delivery of methamphetamine on an alleged different date. It carries the same punishments as count 1 with the same potential sentencing enhancements that I just discussed for count 1. However, if you plead guilty to count 1 and the court accepts that plea, the prosecutor agrees to dismiss count 2. Count 3 is yet another charge on yet another date in February of delivery of methamphetamine. Again, it's punishable by up to the same levels or same amounts, and it has the same potential sentencing enhancements. However, the prosecutor will also dismiss that count and its enhancements if you enter the plea of guilty to, and I accept that guilty plea for count 1. Is that what you understood so far?
Yes, sir.
All right. In file 14041 FH, you are currently charged there with possession with intent to deliver the controlled substance methamphetamine, which is also a felony punishable by up to 20 years and or up to $25,000. In addition, there are 2 potential sentencing enhancements here. One is, again, a second or subsequent drug offender enhancement, which means within the court's discretion at sentencing, that maximum punishment could be increased from up to 20 years to up to 40 years, from up to $25,000 up to $50,000. Or in the alternative, within the discretion of the court, you could be sentenced as a 4th habitual felony offender, which could increase that maximum penalty from up to 20 years up to life. I'm told today you're going to plead guilty to count 1. And if you do, and I accept that plea, the enhancements that I just mentioned will be dismissed. Count 2 is a charge of felony firearm, which is a felony with a mandatory sentence of 2 years. And that sentence would run consecutive to any other sentence for any other offense. That count will be dismissed. Count 3 is a charge of carrying a concealed weapon in a vehicle. That is a felony punishable by up to 5 years and or up to $2,500 plus mandatory forfeiture of the weapon or device. Told that you're going to plead guilty to that count. Now, there's also a 4th habitual felony offender enhancement for that offense, which means that maximum punishment could be increased from up to 5 years to up to life. However, if you plead guilty to count 3, and I accept that plea, the prosecutor agrees to dismiss the 4th habitual felony offender enhancement. Count 2 is a charge of maintaining a drug house or vehicle. That is a high court misdemeanor punishable by up to 2 years and or up to $2,500. Again, there's also a second or subsequent drug offender enhancement that could have increased that penalty from up to 2 years to up to 4, and from up to $25,000 to $50,000. Or in the alternative, you could be sentenced as a 4th habitual felony offender that could increase that maximum punishment from up to 2 years to up to 15 years. However, that count will be dismissed if you enter the pleas of guilty to count 1 and 3. Is that what you understood you were doing today, sir? Now, by entering a plea of guilty, you'll not have a trial of any kind. Does that make sense, Mr. Duke?
Yes, sir.
I'm holding up 2 forms. They are identical. At the top, they each say advice and rights. At the bottom, they appear to have your signature. Is that your signature at the bottom?
Yes, sir.
And did you read through these rights before
sir.
signing? And did you understand these rights?
Yes, sir.
And you understand that if you plead guilty, and I accept that plea, you will be forever waiving these rights as it applies to these 2 cases.
Yes, sir.
Additionally, you'll be giving up the claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements other than the terms of the pretrial agreement, Mr. Duke?
No, sir.
Are you entering the plea of your own free choice?
Yes, sir.
Now, the counsel talked to me about what they believe to be the estimated sentencing guideline range. They told me that they estimate the minimum guideline range to be between 84 and 140 months. The first thing I need to tell you is that the sentencing guidelines are a tool for courts. They are not mandatory. Next, they are merely an estimate, which means they could be right, they could be wrong. You understand? The key question I have next for you is, has Mr. Cherry, probably trying to help you understand potential sentencing, made any promise to you as to exactly what the sentence would be? Has anyone promised you?
No.
All right. Thank you. Do you still wish to enter the pleas of guilty that we discussed? Okay. We're going to first turn to file 14040. As to count one, delivery of the controlled substance, methamphetamine, how do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turn your attention, and while the date range on the felony information says between on or about February 5th and on or about February 18th of 2025, I note that this count one specifically says February 5th. So on that date, on February 5th of 2025, here in the city of Cadillac and Clam Lake Township in Wexford County, what did you do, Mr. Duke?
I sold 2 8-balls.
All right, and what's an 8-ball?
They're roughly 3.5 grams of methamphetamine.
Okay, and so in this 8-ball that you mentioned, you said there were how many?
2 of them.
And those 8 balls again were of the controlled substance methamphetamine, is that correct?
Yes.
Now, in your mind, did you have any lawful right to possess that methamphetamine?
No, no.
And so did you have any, in your mind, any lawful right to deliver those 8 balls of meth? And to whom did you deliver those?
To a CI.
A CI meaning some confidential informant, but
Yes.
somebody you had arranged to deliver them to?
Yes.
And did you receive some money for that delivery?
Yes, sir.
All right. Ms. Carey, do you believe he has provided a factual basis as to that count?
I do.
Mr. Cherry?
Yes, Your Honor.
Ms. Carey, in that file, are you aware of any other promises, threats, or inducements?
No.
Mr. Cherry?
No, Your Honor.
And Ms. Carey, in that file, do you believe the court's compliance with Michigan Code 6.302?
I do.
Mr. Cherry?
Yes, Your Honor.
All right, thank you. Because this is a global agreement, we'll go through the plea as to the next file first before the court accepts that plea. In file 14041, as to count one, possession with intent to deliver methamphetamine. Mr. Duke, how do you plead?
Guilty.
And as to carrying a concealed firearm or weapon, I'm sorry, it wasn't a firearm, it was a weapon, it was a machete. How do you plead?
Guilty.
Again, before the court can accept that plea, I need to have you tell me what you did that makes you guilty of that offense. Turning your attention to February 26th of 2025 in Clam Lake Township in Wexford County. What happens? Were you pulled over by law enforcement? Were you driving a car? Where did this occur?
This one, I do believe, I met up with the TNT officer herself.
Okay.
As a CI.
So a undercover officer
Yes.
had, or you had made an arrangement, not knowing that that person was an officer,
Correct.
with the intent to deliver some methamphetamine.
Correct.
And so how did you get to this event, to the scene?
I had somebody driving.
And where was this? Where did it occur? Not here, not just simply here in Clam Lake Township in Cadillac, where? Business.
So I didn't drive.
Okay.
That was at my work.
Okay, it was at your
Yes,
work.
I was at my work.
All right. And so when so this person that drove you, they picked you up from work and drove you to where the CI was? Or not
No,
the CI, but the officer?
CI met me at my work.
Okay, I understand. All right. And so you weren't there working, somebody drove you to the work.
I was there working.
I want to clarify, Your
Yeah.
Honor, if I can.
Yeah.
Mr. Duke, for the controlled buy, nobody drove you to that. You were at
No,
work.
I was already at work.
Okay.
Okay.
And you had arranged to sell 1 ounce of methamphetamine
Yes.
to this person?
Yes.
And you did sell that 1 ounce of methamphetamine. The address of your work is 324th North Mitchell Street in Cadillac.
Well, did he sell it? Because it's charged with, is it a possession with intent to deliver?
It is, but
Right.
I mean, this is what the facts were.
Okay.
So,
All right. So,
so you had sold that to him,
Yes.
and then after work, you had gotten a ride to somewhere.
No, I went home afterward.
Right.
somebody drove you?
Yes.
Okay.
And you were pulled over by the police at some point while you were driving.
while you were the passenger.
I didn't get pulled over.
So what we're doing now is I'm trying to figure out, so I'm gonna go
If I
back.
can have a moment, Your Honor.
Yeah, go, it's okay.
All right, so
Mr.
what happens was, yeah, but this, I sold this ounce at work.
Okay.
After I got done working, there would have been a few days prior in between relapse. And I ended up going downstate, and on my way back up is when I got pulled over by TNT.
So when you got pulled over by TNT, were you driving then?
No, I was not, sir.
So you were a passenger
I
in
was
the
a
vehicle?
passenger of the vehicle.
And at that time, when they pulled you over, did you have this machete or knife on you?
Yeah, I didn't have it on me, it was in the vehicle.
It was within your area of control?
No, sir.
I'm sorry. I'm sorry. Where in the vehicle was it located?
It was between seat and counsel.
I'm taking it.
No, hold on. Whenever I hear an attorney, a client say, I'm taking it. No, I can't do that.
Right.
So.
It was
I-
in my vehicle.
Yeah,
There we
okay.
go.
All right. Sorry, Mr. Duke. Don't worry. I'm just trying to get us through here. So someone else was driving your vehicle. Is that right? That's a yes?
Yes.
All right. And you were a passenger in that vehicle, correct?
Yes.
All right. And inside that vehicle during the traffic stop, did you guys get pulled over here in Wexford County?
Yes.
At that time, there was a machete in the vehicle. That was your machete. Is that right?
Yes.
And I'm going to ask you, how long was this? So when I use the word machete, I grew up on a Christmas tree farm, I have an idea what I mean, but I want to know what you mean. Was it a big knife?
Yes, sir.
All right, so it had like a sharp edge on one side?
Sharp edge on one side, shredded on the opposite.
All right, thank you. Now, we're gonna go back and ask just this, I'm a little confused here, but we'll get to it. At that time when you were pulled over, did you have any other methamphetamine in the vehicle that you did intend to
Yes, sir.
deliver? And so how much did you have in the vehicle that day? It's okay. I think you're confusing the two files together, but that's okay. We're almost done.
This is when that's how much you said.
Yeah, it's okay. Mr. Duke, you go ahead. Mr. Duke, go ahead and tell me what you were, see, here's what we're doing.
There was 6 ounces in the vehicle.
Okay. So when you got pulled over, the same time that you were coming back from downstate and had the machete in the vehicle, at that time, when you were pulled over in Wexford County, you're telling me that you had 6 other ounces of methamphetamine with you.
When I got pulled over, yes.
Okay. And was it your intent with that 6 ounces, which by the way is quite a bit, you intended to then deliver that to someone at some time?
The day before I went down, TNT pre-asked me for 2 ounces.
Okay.
I told him I ain't got it. I gotta go down and get it.
So you went downstate to get more methamphetamine
Yes.
and brought that back up to Wexford. And when you got pulled over, that was some of the methamphetamine that you did intend to deliver based upon the arrangements you had made with
Yes,
the
sir.
confidential informants or officers, correct?
Yes, sir.
All right. Ms. Carey, do you believe the defense provided a factual basis as to counts 1 and 3? Mr. Terry?
Yes, Your Honor.
Ms. Carey, do you believe the court's compliance with Court Rule 6.302?
Yes, sir.
Mr. Terry?
Yes, Your Honor.
Ms. Carey, in this file, are you aware of any other promises, threats, or inducements?
I'm not.
Mr. Chair.
No, you're not. No, Your Honor.
All right. The court finds the defendant's pleas in both cases to be made freely, knowingly, and voluntarily. The court further finds that the information provided by the defendant under oath satisfies the required elements of proof for each offense to which he pled guilty. Therefore, in file 14040, The defendant is found guilty of count 1. The remaining enhancements and charges will be dismissed at the time of sentencing. In file 14041, the court finds the defendant guilty of count 1 and count 3. The remaining counts and all other sentencing enhancements will be dismissed at the time of sentencing. Mr. Duke, these two cases will now be set for sentencing at the same time. That sentencing will most likely be in about 4 weeks from this coming Monday. We do sentencings every Monday in this courtroom. Anytime someone's convicted of a felony in a court in Michigan, the Michigan Department of Corrections, also known as the Probation and Parole Office here locally, must prepare a pre-sentence investigation report. That report will discuss the offense, discuss the pretrial agreements for offenses, will discuss information about your prior criminal history, tell me about your probation, parole history, your bond history. It will also include a score in the sentencing guidelines, which again are not mandatory. They are, however, a very valuable tool that the courts must use to take into consideration in establishing a reasonable proportionate sentence. It will also include a recommendation as a sentence, but keep in mind, it is merely a recommendation, as it is the court alone that will determine a sentence. There are 3 steps that involve you in the preparation of this report. Number 1, you're going to get some packets, and I see that those have been provided by the clerk to the bailiff. You'll open that packet, follow the instructions, answer the information, and turn it in. Number 2, you'll be subject to an interview with an agent from that office, and you have the right to have your counsel present during that interview. And number 3, Mr. Cherry will go over that report with you prior to coming back to sentencing. That's important because each side has the right to make objections or corrections to the contents of the report. Now, some of this report might include details from previous cases. You still want to pay attention to them if there are any errors. I often can find errors. I find them every Monday morning from other judges, other courtrooms, other probation officers, and we like to make sure that we get them corrected so they're not in error when somebody else picks up the file. That's why it's important that you look at those. Anything else, Ms. Carey?
No, thank you.
Mr. Cherry?
No, Your Honor, thank you.
The court revokes bond, remands the defendant to the custody of the Wexford County Jail. We are adjourned. Thank you folks for your time. All right, our next case is more.
Okay, my friends, you know it, you love it. It is the simultaneously worst courtroom on the internet and the best because it's the worst. Da 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 Dungeon Court. Have fun.
And you're Ellis Smith?
Yes, sir.
Well, we've got a driving under a suspended license and 25,385, and then you had a theft offense for Jack Community Service and fines to pay. You did make a payment yesterday. What's going on with your driver's license?
Your Honor, I don't know, there's something going on out of Wayne County. I'm trying to get over there and they can't tell me nothing. I got to go over and see Cerrito or whatever over there.
Yeah. Mayor's Court or?
I think it's who I've been calling. I've been trying to get information. They bend them over a motorcycle endorsement or something. I don't know what they're.
Are you asking for more time then, or what?
If it's available. I know it's been a while, Your Honor. So.
Yeah, it looks like it was back in June, May or June of 22.
22, I think it was this year.
Well, I'm looking at, maybe there's another one, I'm looking at what's on your driving records now. So I think maybe we just need to go ahead and get it over with, it looks like there's that's not the only one. We've got other issues on here. Let me look at your report. Okay, it says vehicle, this is what the officer wrote, vehicle had expired plates, so that's a legitimate reason to stop you. Then you check your license and it was suspended. On US 52.
Yes, sir.
Okay, anything else you want to tell me about it?
No, Your Honor, if we can get it over with if you want, that's fine.
Yeah, that's what we're gonna do. Okay. I'll put a $100 fine, court costs. And set review hearings for you on both matters for August 22nd. 9 o'clock, August 22nd.
Okay. Thank you, Your Honor.
You're welcome.
State of Ohio versus Richard Akers, case number PRC 25-1629 A&D.
All right, you're Richard Akers.
Yes, sir.
Mr. Akers, the state's election on July 4th at 7:33 a.m. in Perry Township. You were operating a vehicle under the influence of either alcohol or drugs, or a combination that you refused to take tests. So it alleged to be your first offense, so the maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days of treatment, $375 fine, 6 months license suspension. You're also charged with failure to control. Looks like it was a one-vehicle accident involved. And that's a minor misdemeanor, maximum penalty $150 fine. You understand these charges?
Yep.
You understand your rights?
Yep.
How do you plead?
Not really.
Yeah. Okay. Are you working on?
No, my Social Security, sir.
I'll appoint Mr. Smith, Roger Smith, and you should give those documents you got there, I'll give them to you all. He's here, so we'll get him in the court.
Okay.
Mr. Smith.
Yes, sir.
Richard Akers, he has a offense, ODI, with an alleged refusal, which he's disputing. He's got some medical records to give you to look at concerning that issue. Since he appeared on his side, he can sign a $1,500 signature bond.
Thank you, Judge.
And I'm setting pre-trials July 25th or after.
I'm here the 28th,
Okay.
or the first 28th fine.
July 28th will be the next one. The pre-trial at 10 o'clock, July 28th.
Will he need fingerprinting, Your Honor?
And he will have to go to jail with fingerprints, conditional bond.
Okay. Once he gives that paper, you're free to leave. I'll give you.
Okay, that finishes the arraignments we have. We'll start the pre-trial.
State of Ohio versus Spencer Johnson, case number CRA 20.
Well, the next doomed soul comes up. Just a reminder to channel members that you do have the ability to request the Dungeon Court brochure that we made. You can get your PDF copy. All you have to do is reach out via the member email. So just a reminder if you don't have your copy already.
And that charge to a misdemeanor of the same section.
This be an M1, 7F5.
Yes, Your Honor.
How does Mr. Johnson plead to the amended charge?
Guilty, Your Honor.
Is that correct, Mr. Johnson?
Yes.
Do you have anything you want to tell me about it?
No.
Okay. I'll impose a $150 fine, or you pay the court costs, 15 days in jail. I'll suspend 4, give you credit for 11 days you've already served. So there'll be probation of 2 years, level 5, which is non-reporting, accept, we'll have a review hearing on January the 16th.
Your Honor, he's going to go ahead and pay the fine and court costs before he leaves today.
Oh, okay, if he does that, then I'll terminate the probation.
Okay. Thank you, Your Honor.
See the clerk.
We'll do that now, Judge. Thank you.
You're welcome.
State of Ohio versus Connie or Caney Burnside, case number CRA 25358. Mr. Stratton, okay.
Connie Burnside, also Connie Burnside Mr. Stratton's case is set for hearing actually,
Yeah, Your Honor.
it is at 4.
Yeah, it's possession, Your Honor. She's here.
Connie Burnside,
Did you say Connie Burnside?
K-A-N-I. Connie,
Oh, yes. He's here.
Okay,
I thought he was here.
well, we'll recall him down the courtroom.
Okay.
State of Ohio versus Molly K. Douglas, case number CRA 25263, CRA 25264.
Your Honor, when you were saying that name, it just wasn't registering with me.
Allie Douglas is here, it's set for Humphrey Charles, Mr. Stratton.
Good morning. How are you?
Good, how are you?
I'm doing good.
May I approach, Your Honor?
Yes. Good, thank you. You're welcome.
Good.
Okay, it's a good report. And you are working?
Yes.
Okay.
Just continue on, Your Honor. I think that once she completes this, hopefully that'll result in a dismissal of these charges.
Okay. Let's come back at first part of August. What's your schedule in August, Mr. Stratton?
Your Honor, I am not available the 4th, 11th, and 18th.
Let's do the 8th, August the 8th.
That'll work.
Okay, good start. Keep it up.
Thank you. Have a good day.
Good.
State of Ohio versus Caleb J. Langdon, case number CRD 25251. Caleb Langdon.
It's Mr. Stratton's case, pretrial.
My approach.
Yes.
Are you not done with the parenting class yet?
Next week.
Next week?
My last one.
Okay, great. Your Honor, he'll be done with the parenting class next week. I think that was the big thing that we were looking at him completing.
What's the state's position on this?
We want him to continue on and finish his treatment. I checked with Children's Services today to see the status of anything that they might have pending, and and they closed the case previously with the understanding that he was in treatment. So we're satisfied with that part of it. We're just wanting to go ahead and, I didn't get a chance to see the report. I'm not a very fast reader, though. Is the only problem.
Catch up?
As long as he's in good standing?
Yes,
Okay,
very
so we're
much
just
so.
wanting to complete his program.
Keep it on Friday, is that better?
On a Friday, yes, yes, sir.
And did you say you were available the 15th?
The 15th of August?
Yes.
Yes, I am.
Okay, August 15th. Be the next hearing. Hopefully we can resolve.
Thank you so
that.
much. Thank you, Your Honor.
Thank you.
State of Ohio versus Sharon Meadows, case number CRB 25374.
And there's a cross filing on this too. Marcus Folks.
Yes, I'm here. State of Ohio versus Marcus Fultz, case number CRB 25375. I'm here.
Okay. It's Mr. Smith's case, Mr. Stratton's representing Ms. Meadows.
Your Honor, prosecution has agreed that if there's no problems for 90 days, that they're going to dismiss both charges.
On one payment of court costs, Judge.
One payment of court costs.
And do we have a case we're going to assign that to the court costs?
Mr. Folks, can you pay court costs? They will dismiss your case upon payment of one court cost. Can you pay that in 90 days?
Yeah.
When we come back? Okay.
Yes, sir. Yes, sir.
Sign it to Mr. Folks' case, please.
So that's going to be October the 10th?
I'm actually not here that first week of 2 weeks of October, Judge. But if it's a dismissal, I could jump on Zoom, I guess, if I had to. But
No, we can make it 17th,
yes, I'm here at 17th.
October 17th, Mr. Stratton.
Yes, that's fine, Your Honor.
All right, next hearing is October 17th. Be dismissed. Then, if there's no further problems, and costs are paid by Mr. Falk.
Do you require an appearance, Your Honor?
No appearance required.
No appearance required.
If all those things happen.
Just make
Would
sure he
the
pays it.
cost be 150?
Should be.
No problems.
But
I would-
sheriff-
I would think.
Okay. Good? All right, good.
All like the $25 application, so $175. I tell you, Marcus, check with the clerk, but I think it's $175. You pay that in the 90 days, then we'll get the case dismissed. No further problems.
Yes, sir.
Good deal, Sharon.
Okay, that's all.
Roger.
State of Ohio versus Amber Mills, case number CRB 23621, CRB 23556.
Mr. Stratton.
Yes, yes, I was asking about that. Yeah. Don't you like it? I'm sorry, that's bad joke. I apologize. Just trying to make it a little bit less stressful. Yeah, a little less stressful. That was-
Mr. Mills, is that hometown?
Yes.
Good screens. Positive report.
Your Honor, it looks like she's doing well. I'd like to continue with that. She does have an ankle monitor off. I think it might be, would ask the court to remove that. I think it might be time to do that.
I have a job interview in Ashland on Monday, and I can't go because of this.
State take any position on it?
I know there might be,
She has an ankle monitor. Does state take any position on whether that should stay or be removed?
We are in favor of whatever the counseling agency and the court thinks should happen.
Your Honor, I know she She'd only been with us for a few weeks, and I know that was a rough patch. I hate to make a recommendation and something happened, but if you think that it would be okay, then.
Well, I've been wrong before. I think the last time I removed ankle monitor, the guy bolted as soon as I took it off. And he'd been in there longer than she had.
I will not be doing that. I have to stay close by. I have a son, so.
Well, you know,
In
nobody
town.
ever tells me, Judge, to shake that.
Oh, I know. Yeah.
But they just do it.
No.
The thing with Amber though is she may leave treatment. She's not gonna leave Lawrence County. Right. She always comes back. It's like a homing pigeon. She never leaves. She'll leave for a while, but she'll come back here. So we'll get you eventually.
Yeah, it's not worth it.
Not
I've
like you're
learned
gonna
that.
move to California or something.
No, it's not worth it anymore. I'm just ready to get this all over with.
Okay, I'll order ankle monitor removed.
Thank you.
Don't make me look bad.
I will not, sir.
And August the 8th for the next hearing, Mr. Stratton, I think you're here then.
Yeah, I think that was a good date, Your Honor.
August the 8th, for your next hearing.
Thank you, Your Honor.
State of Ohio versus Brandon Tommy, case number CRB 24-4, CRA 24-191.
This is Mr. Stratton's case.
Yeah, I think she's just sitting outside with the baby, Your Honor.
Okay, I'm going to do the same with what I did with Andrew. I wanted to get screened today for my own satisfaction.
Okay.
All right, so go get a urine screen done.
State of Ohio versus Jared Meredith, case number CRD 2462, CRD 22920, CRD 2236A and B, CRD 22263, DRC 2206.
Mr. Stratton's case, set for briefing.
Yeah, Your Honor, he has apparently left treatment, but he also has new charges that you do not have. So they're not filed yet, so.
Okay. From something that happened in treatment or?
No, so, I don't know, maybe. Oh,
just
okay.
left us.
Yeah, no, I didn't think it was treatment. But, oh, it was different. Actually, I believe they have their new charges prior to these charges.
Okay.
If that makes sense.
All right, he's got several files. There'll be bench warrants issued for failure to appear today. Thank you. Late treatment.
State of Ohio versus Charles Nance, case number CRB 25331, CRB 23386, CRB 25291, CRB 2537, CRB 19237.
Judge, I was provided a copy of the DVD this morning. I need to get my client in the office to look at that. We can come back relatively soon, August 1st, if that's not a terrible date.
Did you say August 1st?
Yes, that's
Okay,
what I
that
was.
works. August 1st will be the next hearing of Mr. Nance on all cases before the court.
Thank you, Judge.
Your Honor, just for the record, he has done community service. We've done 8 hours, I believe, since his last.
August 7th. It's in here too. He's in all cases on his first time. You got it.
So while Dungeon Court is between contestants, I did want to point something out quick. Barbara had mentioned getting like a cash app for Ellie, and I made a note. We can certainly explore that. But one thing that was requested in several emails that I got was the ability to get Ellie treats like directly. So if you go to courtroomfiles.com and you click on Ellie at the top of the page, you'll get to Ellie's page, where it features some fun stuff about her and the merch and whatnot. But at the top, there is actually a link, Give Ellie a Gift, and that links out to an Amazon list of things that both her and Io enjoy or would enjoy. That is not put out there for you must go run and do this right now, but I actually put that up a couple of weeks ago and forgot to tell you guys it was there, but it is there by request. So if that's something you want to use, again, courtroomfiles.com, and just click on Ellie and you'll be able to find that. Anyways, back to the dungeon.
Let's go to the tape.
I'll go to my home.
I said, say my password is invalid.
I said that last time, I was using this time, but that's what I said last time, I said I was using this time. Okay. Well, Judge, this is a case that I spoke with the prosecutor. I think at this point, she's going to be ongoing services with OVP, that there will be a dismissal and the fire will be returned to the grandfather. He's not interested in pursuing the charge.
The last time we were here on June the 20th, Ms. Short did not have a report from OVP, and we wanted to have one for today, just to make sure she was still in treatment. Is that right? Am I right?
You're still in treatment?
Yes.
And anyways, she's brought a report today. And she says she's going to continue in treatment. So I think, and as far as the gun that was used that belonged to her grandfather, and we would be okay with that gun being released back to him. And if the court's satisfied that she's complying with her treatment and it's going to continue on, we'd be okay with going ahead and dismissing the charge today.
Who is the grandfather?
Your grandfather's name?
Richard Connor.
Richard
Connor?
Connor. I take care of him.
C-O-N-N-E-R?
Yes.
Okay, the state's willing to nolly the charges. The weapon that was confiscated will be returned to Richard Connor. It's according to the affidavit, Denali, D-E-N-A-L-I, .38, all caps, A-C-P, and the numeral sign, K, capital K, 15020. So you would need to get a copy of that judgment if you take it to the sheriff's office.
I'll make sure she gets that judgment. Thank you.
So there's a request to dismiss it without cost, Mr. Haley?
Yes, Your Honor.
Okay, so no court costs to be dismissed. Again, return to the grandfather.
Thank you, Judge.
State of Ohio versus Amy Van Zandt, case number TRC 25830.
She had car trouble. I hope that's, is that her? Amy?
Yes.
Okay.
Yes, sir.
Okay, yeah, hang on just a second. We're just making sure you were online.
And this is set for a pre-trial.
It is, Judge, I received the drug test results this morning. She's not here to go over them. If we could come back in a couple weeks. The 28th of July or the 1st of August are both.
Let's make it August 1st.
I can do that.
August 1st will be the next hearing, and you want to be here in person.
In person, Judge. And Amy, I'll get you in the office for August 1st. We'll go over these test results and talk in my office.
Okay, sounds great. I appreciate you all.
All right.
10 o'clock, August 1st.
10 o'clock, August 1st. Put that on your phone.
10 a.m. August 1st. Thank you.
All right. I'll be in touch.
Appreciate it.
State of Ohio versus Ethan Anderson, case number CRA 24706. Ethan Anderson.
Ethan Anderson is Mr. Tyler Smith's case. Ethan Anderson.
Your Honor, we just got him from the jail from Ironton Municipal and was not informed of his court date up here. I'll make a phone call and get him up here if you would like.
That's fine, if he's compliant. I'd order that he comply with our municipal orders on treatment.
Yes, sir. He's doing well in the program, compliant with all of their recommendations.
Okay.
Yeah, I believe the last time we were here, he was still in
jail.
Jail, because he had a hearing coming up in Ironton. I believe he had to serve, so I wasn't aware that whether he got out and went to a new, because he was at Bethesda the first time and left, and then he served, so.
When do you, let's say it 2 or 3 weeks.
That's fine.
What's your availability? August 1st? Or
August 1st, be fine, Your Honor.
August 1st for pre-trial on review.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Austin Hawthorne, that's number CRB 2357, CRB 2358, CRA 2357, CRB 2843.
Mr. Morford's case.
Your Honor,
Was at the council this morning.
Mr. Hawthorne was placed in custody and is bonded out because he didn't give a urine screen last time. He has approached me today and we're trying to get a urine screen off him. We've not been able to get one yet.
Okay, we'll recall it later.
State of Ohio versus Robert E. Gensley, case number CRB 23324, CRA 21345, CRB 21346, CRB 21222.
This is Mr. Morford's case, I believe.
Yes, Judge.
We still have 23-324 still unresolved. There's other cases where he's got sentences that he's to be working on.
Your Honor, the House manager at Newness of Life was supposed to have sent you by email a progress report
got older, so I don't have anything new.
Is that a copy of it?
I've got one, May 27th, that's the last one I've got.
7/10. Judge, I have a letter dated 7/10 on his tablet, if you care to read it from the tablet.
Okay,
He told me he emailed it to you, so maybe he didn't.
take a look at it. It says you're gonna be graduating June 17th, so that's already happened, so is that the wrong date?
It might be the wrong date. He had another typo in there too. He had to change it before and resend it to me.
Yeah, it says graduates June 17th, and it's dated July 10th. The one case that's still pending is an assault involving Christina Burson. I don't know how the state wants to handle that. It looks like somebody she had, there was a relationship there from the affidavit. Ex-boyfriend, I think is what she says.
Well, at sometime in the distant past, the victim was stated that she was satisfied for the defendant to get treatment. That was back in, I guess, 2023.
Well, we just need a letter, and then we get that one taken care of, we get a letter of completion. So then, it says you completed, but it's obviously the wrong date.
Yeah, he got the wrong date on there.
So let's come back again, and hopefully we'll have something saying you completed, and you'll still have to work on the stuff that you got. You still have bonds. And court costs. On your old cases, and that's it. There's no community service.
I got money. I've been paying them.
Okay.
It's just a lot.
So, are you still actively seeing the people at Weakness of Life?
Yeah, I'm there.
Okay. So let's make it a month then to get it resolved and get us a letter of completion. Somewhere mid-August, Mr. Morford, what's your schedule?
The 15th, Judge, the 22nd, 29th, 25th.
15th, August 15th will be the next thing.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. State of Ohio versus Tony Brees, case number CRA 25398.
All right, this is our Rule 4 to Delaware County. Said that he posts the bond. He hasn't posted the bond. There's nothing in the file on the bond. He was ordered to, he posted a bond to turn himself in before today's date. Are we sure he's not in the jail?
Tony Brees, he wasn't given to me as being in jail, Your Honor, but I never got a full jail because of the complications that happened.
Okay, we'll check on it, recall later in the docket.
State of Ohio versus Malachi McComas. Your Honor, this is set for a
Your Honor, if I may, Delaware County will become a big Mr. Grease up.
Okay, so
Just $95 jail.
his case here will be dismissed at 25-398, be dismissed as he was picked up by Delaware County.
State of Ohio versus Malachi McComas. Malachi McComas.
25-17, Malachi Thomas. This looks like a arraignment.
Yes, sir.
Malachi Thomas was summoned.
Your Honor, I represent Malachi McComas in Portsmouth Municipal Court. I've been in constant communication with him. I was not aware of these charges. I will try to get him into court. I actually will text him right now. That's such a unique name that I assume it's the same person, so.
Yeah, it's a 3009 Walnut Street, Portsmouth.
Yep, that's him, yep.
And it's a possession of a drug use instrument.
Yeah. I'm not sure where he is right now, but I'll text him right now, and maybe we can do it Friday, maybe, or Monday. See if I can get him into court on Monday.
According to what I have here, he was summoned to be here today at 9.
Okay.
So he's got 7 days to get in for a warrant hoist.
All right, I'll text him right now.
State of Ohio versus Melissa LeGrand, case number CRA 24513, CRB 24462.
Morpher's case. That's a good report, says she's making progress, dealing with things.
Barbara, thank you for the $5 saving for merch, but you're the best host on YouTube. Thank you so much. I really appreciate that. Those are very kind words. And again, thank you for the 5.
She's already entered a plea that we had delayed sentencing while she was going to treatment. Is it time to do sentencing now?
We're okay with that. One of the things that we wanted to make sure of was the restitution, which is kind of sizable. But,
Do you have a figure for that?
Yeah, I think Jasmine might need to figure out.
Yeah, we had that.
I know.
Is it on?
It's somewhere in here.
Well, it was on to each charge, let's see. So
We do have.
it's all paid. Well, one is here.
At least we think we have.
If you just put the last Simpson out, this is one being missing. So on this case number, The restitution goes to the landlord, if you remember, because this was a rental. And here's the figures. We got broken down on all of this. Okay, you can see that you take off the paperclip, because these are all different.
We do have. Jasmine has it figured out and I don't.
So, here, on this case number,
You want us to go
it's
ahead and
that
talk
amount.
about that, Your Honor?
If you're ready, Mr. Morford, you ready to do that?
Yes, Your Honor.
See, on this case number, it's this amount that goes to me. Because this was that house, this was a rental, which is that 2, 4,
So, in 24 CRB 462.
yes,
Okay.
that's her estimate.
There is $2,457 that is owed to Ellen Parsons.
What's the name, Eleanor?
Ellen,
Ellen.
Ellen Parsons. She's the owner of this property. And do we have the address for her?
Yes.
Yeah.
Let me see.
Okay. 80.
Zero.
All right.
Slowly but surely.
I have an address for her. It's 18080. 18080. State Route 243 in Chesapeake. What's the next one?
What, is there an agreement as to kind of restitution and what it's for, or are we gonna?
I don't have any reason to question Mr. Hill's figures, Judge.
Okay.
So, on these case numbers,
She's indicated to me that she would make payments on, although keep in mind, she's only working part-time at Pizza Hut, and it's not going to be sizable.
so, Teddy Stanley, this is his restitution.
Okay. On 24 CRA 513, the victim is Teddy Stanley, Teddie, Stanley. And the amount of restitution is $2,733.85. Do we have an address for Teddy Stanley?
It should be,
I'll look for Teddy Stanley's address.
Do you have anything to say? Go ahead.
it's his residence.
I thought that's what we was going to do. It's okay.
Okay, so Teddy Stanley's address is 18083 State Route 243 in Chesapeake. 18063. I'm sorry, 18083.
Must be neighbors to the
Yes.
person. And that's on, case number 513, 24513.
Yes, Your Honor. And then, and then 24 CRA 515 and 24 CRB 514B. Church of Christ, and that is in Chesapeake. And I don't have a street address, but
That person over, he's like a whatever church.
and there's a $500 deductible on that one.
And that's for both cases?
Yes. Is that it?
Yep. That's it.
Thankfully, that's it.
It was so confusing getting it all together. Sorry.
Is that two, 500?
Just 1.5.
1,500. Okay.
Okay, so we're ready to complete sentencing then, Mr. Morton?
Yes, Your Honor, I believe so.
Is there anything you or Ms. LeGrand wish to say?
Judge, I would just ask you to take note of her progress through hometown, and she is trying, she is establishing her life. She's gainfully employed, has a place of her own now, and is returning to sober life.
Okay, that is commendable. And I don't want to minimize that, I appreciate that. And I always, I think I have a reputation trying to help people that have substance use issues. But my philosophy is you still have to pay for whatever you did. It's no excuse that you were under the influence or had substance use issues if you cause damage to someone or violate the law. You still have to take care of that, make restitution, make amends for whatever you did. So that's part of the process of getting clean and sober. Take care of the damage you caused during the time of your addiction. So this is part of the process. So, all right, Ms. LeGrand, congratulations on doing well. And I want to discourage you from continuing to work. These restitutions are going to be a part of what you need to do as your process of recovery. Anything you want to say?
No, sir.
Okay, on 513, which is the vandalism involving Teddy Stanley, I'll impose a $200 fine, which I'll suspend as long as you complete treatment. Order you to pay court costs, 30 days in jail, all suspended. Restitution to Teddy Stanley amount of $2,733.80. Is it 84 or 85 cents? 85 is what I got.
85.
Okay, and level 4 probation for 2 years. Complete treatment at hometown recovery will be part of the sentence. Set our first review hearing August 29th at 9 a.m.
Sorry, August
29th. 515 and 514 we can do, kind of do together. This is there was a resisting arrest. What do you want to do with that? That was the A case on 514.
My understanding was she pled guilty to that back on November 25th. Oh, okay, as far as the sentence, we don't take any position. We're happy that she's gone through this lengthy transformation and that she's gotten herself in the right direction. So we'd be okay with the suspended jail sentence.
Okay, so I'll do the same thing. $200 fine, suspended on the conditions you finish your treatment. I'll suspend even the court costs on that because they're rose at the same time. So no court costs, 30 days in jail suspended, complete treatment at hometown recovery. Same review date, August 29th. B case was the one involving the church again, so, $200 fine suspended, complete treatment. There will be restitution to Chesapeake Church of Christ for $500. It's deductible on their insurance policy. Same review date, August 29th, 9 o'clock. Yeah. Same probation. And 24,462.
$62.
462. Some criminal damage and $200 fine suspended on completing treatment. There will be costs on this, because it's separate. Restitution, and 30 days in jail suspended. Days suspended, restitution to Ellen Parsons, ELLEN Parsons, PARSONS, amount of $2,457. Okay, she'll need to meet with Mr. Major in probation, and then she's free to go.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
Okay, so we got to end there because anytime the court from hell demands restitution for a church, the world has changed. so we'll call it there. Thanks, everybody, for everything today. I hope you all had fun. I know I did. It was a good day. And it will continue to be a good day, and it'll be a good weekend, too. Just make sure it is. And that's just by working each moment as it comes to you and doing the right thing in that moment. And the next thing you know, you've had yourself a great weekend. So do that. I'm going to go do a bunch of things. My lists have lists, so we'll see how all that works out. I may pop in over the weekend and say hi. Not sure how, but you never know, so keep an eye on the channel. And again, appreciate everybody. We'll see you again Monday, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. And I look forward to seeing you all soon. Take care. God bless.